Is it a contempt petition? They are not. Just take it, man. Yes. What is the matter? Is it an appeal or what? Okay. Excuse me.
License under would be a payment solution. So priority was under National Highway Authority of India. As we protect National Highway roads for National Highway Authority in a period of 12 months. All NOCs, everything is come, and prior to that, in the year 2002, they've already granted me the license.
What is the relief? What is the urgency?
The release is now the project is granted to me, but the Department of Mines and Geology is not granting me, asking one more time NOC. This I had approached this honorable court and get granted.
But you have removed the objections.
I've removed the objection, Your Lordship. Tomorrow or day after tomorrow.
No, we'll give you date.
At the earliest, because it's already 2 months over, Your Lordships. I've been granted the license. I'm requesting, and this is
1 minute, ma'am. Just take it. It's our roster. It's a convenient day.
one more matter, Your Lordships. It's
Yes.
covered matter, Your Lordships. This honorable.
What is the matter?
It's a mines matter again, Your Lordships. Under Rule 5(2) of the Karnataka Stone Crusher Regulation Act, the lease is being substituted. The section is being substituted for granting. Removed objections, Your Lordships. Only for 20 years it has to be granted. Deeming fiction, Your Lordships. Karnataka Stone Crusher Regulation Act.
One more similar matter. Since 1987, I was holding the license with respect to the mines, and time and again it was extended, my lord.
Objections removed?
Yes, my lord.
All.
I applied with all the objections.
Just take it.
Fresh matter.
One matter, my lord.
Please come this side. Don't jump.
The
Yes.
first matter, my lord, it's a commercial appeal. The appellant, my lord, has suffered an ex parte judgment and decree, my lord. Now execution proceedings have been initiated.
You have not sought the setting aside.
I've sought setting aside in this commercial
Application not there. No.
appeal. No, my lord.
No, execution is when?
Execution is on the 10th, my lord.
When did you come to know about the ex parte?
My lord, I came to know only when the execution proceeding summons was issued to me, that is on 10/6, my lord. And
Just
the next
take that,
date was
man.
posted
When is the execution?
10/7.
10/7.
Please have it tomorrow, my lord.
10/7? Acha, okay.
10th of
Just
July.
have it, man. Just see it.
All office.
So is it coming after notice for the first time, execution?
Yes, my lord.
Take
No,
a date there. We'll give you a date here. Let's give a date.
The issue, my lord, is that they're issuing warrant against the deliverables.
Take it, man. Just see it.
Request for tomorrow. my lord.
Just see it first.
Lords, this is a fresh contempt petition.
Just 1
my
minute.
lords.
You see it. Just say also when the 10th is later, you have filed an appeal. Give a date, ma'am. Give a date. We'll give you a date. Yes.
My lords, this is a fresh contempt petition. The learned single judge has issued a direction to consider our application under Karsamadana scheme. It was directed to consider within 30 days.
Just take that. ma'am.
Date may be given, my lord. We have cured all the objections.
Mine is a commercial appeal. The trial court, I'm a teacher. The trial court has virtually passed an order directing me to furnish security.
You are a teacher. How is teacher relevant for the dispute?
No, my lord, I just bring. I have 4 weeks time.
Have you removed the objections?
Objections are removed, my lord.
What is the urgency?
My lord, I have to furnish security within 4 weeks from the date of impugned order, which is 16th June. That's expiring next week, my lord. on
Just take
15th.
it next week. ma'am. Not-
On the last date, my lord, before the execution court, we made a request that the commercial appeal will be filed.
So you have filed it. We have given a date.
But the court wasn't accepting, my lord, they were willing to issue a delivery warrant for deliverable of movals.
Go and tell that appeal has been filed.
You know, the same submission was made at the last.
There is a difference. Appeal filed now, date given. Tell them. We'll just give a date, ma'am. Give a date, ma'am, in this. How? 20? If they issue warrant, then move again to us. Okay? We are giving you the. Yes, ma'am.
Review petition, your lordships. Both the writ petition and the writ applications were dismissed in
No,
spite
but
of
which bench has passed the order?
Chief Justice, your lordships.
Just show us that. Ma'am, just take these details. No, but this need to be. No, 1 minute. It should be. You go to Registrar Judicial.
Please, your lordships.
Yes.
Lords, commercial appeal, my lords. I've gotten to know about the OS, my lords, only when I was issued notice in an execution petition. Now they've already attached my property, my lords. The property is worth 20 crores, my lords, 10 crores, my lords, and the attachment is only 50 lakhs, my lords. And it's an ancestral property, my lords. The urgency is this, my lords. Kindly have it tomorrow, my lords.
Give a security there.
Lords, I've not even been allowed to file objections, my lords. When I entered appearance in execution, they're already attached property. They're already issued directions to attach my property, my lords.
Then why don't you go back? It's only for you and give a security to the extent or some bank guarantee to the extent of 50 lakhs. That's only to ensure there is a recovery of that amount. That's all the attachment is about. Nothing more.
Please, my lords.
Oh.
I have no impediment to do so, my lords. But my property is already already directions been issued, my lords.
For attachment.
For attachment, my
What
lords.
do you mean by attachment?
They've asked for the attachment of my share of. They've asked for, my lords. They've asked for attachment of my share of the
What do
ancestor.
you mean by attachment?
They're going to.
It's only to secure that 50
Please,
lakhs.
my
That's
lords.
all.
There will be an encumbrance on that property to the extent of 50 lakhs.
Please, my lords.
You give banks guarantee there, they will remove that attachment. They are not going to sell it immediately, isn't it?
No, my lords, but it's an ancestral property.
We'll tell you, even suppose you come this appeal, then also we'll say, how will you secure 50 lakhs? How will you secure? By depositing the money?
Please, my
You
lord.
can say so there. If they don't do it, come back. Okay?
My lords. My lords, I was not even given an opportunity to
When
be
is the
heard,
date
my
now?
lords.
When is the date
Date is
there?
on 15th, my lords, but it is already attached.
So when was the order passed?
My lords, the order was passed 2 weeks back, my lords.
Just take that.
My lords, for tomorrow, my lords.
We don't see any urgency. We will list it.
Please,
Okay?
tomorrow, my lords.
Contempt petition, my lords. This honorable court has ordered the BBMP to demolish
Just
the.
take that, ma'am. Contempt. Yes, ma'am.
Huh?
Commercial appeal. Yeah.
The trial court we have challenged the arbitral award in the trial court. It's been dismissed. We have filed commercially. All the office objects are
You
complied.
succeed. You filed the petition before the trial court.
Please, your lordships.
It was dismissed.
Please, your lordships.
Just have it after. Objections removed.
Please, your lordships.
Have it after 2-3 weeks.
My lords, a commercial appeal, my lords. Our
One
petition
minute,
has been
just 1 minute.
dismissed.
Mr. Ramesh, you tell us.
My lord, four
Just 1 minute.
arising out of common order, my lord, passed by the honorable single judge. PBMP is before your lordships by filing 4 writ appeals. Lord, this is a matter, my lord, which pertains to improvement expenses, as and when, my lord, the property they apply for plan sanction. Lord, they are supposed to, insofar as the villages in and around Bangalore, my lord, they were supposed to pay improvement expenses those days in the year 2015. These orders were challenged before the learned single judge. Initially, there was a stay. Thereafterwards, my lord, undertakings were given by the petitioners therein. Lord, pursuant to that undertaking, my lord, they have already deposited these amounts. Now, learned judge, my lord, says that you refund all these amounts to the concerned.
You are appearing for whom?
I am for BBMP in this matter, my lord.
Is contempt filed in that?
Now, contempt has not been filed according to me,
Take
my
it,
lord.
ma'am. Take it.
What I have verified is contempt is not filed. Lord, 4 appeals, my lord, objections have been removed.
All removed?
Yes, yes. It
Have
is
it
ready
after
for
2 weeks.
preliminary hearing.
My lords.
My lords,
Writ appeal,
it's a
my lords.
commercial appeal,
Just
my
1 minute.
lords.
What is this?
Writ appeal, my lords. There
What
was a,
agency, ma'am?
there was an order for non-compliance, my lords. It was a conditional order that subject, it has to be.
They file an application?
Yes, my lords, I filed an
We'll have it,
application.
those application after 2 weeks.
My lords, it's a commercial appeal, my lords. Our petition was dismissed by the trial court by order dated 4/4, my lords. It's a normal commercial appeal before my lordship.
You are what? You are defendant or
We are
you
the
are the
player.
plaintiff?
Where are the plaintiff in the lords?
Objections removed?
Yes, my lords.
All?
Yes,
Court fee paid?
my lords.
Court fee?
Paid, my lords.
My
It may have on 21st, my lords.
She will give you date. She will
Sure.
give you date.
Grateful.
My lords, it's a fresh contempt.
Yes, who is there? You have any mentioning? Yeah, go ahead.
Commercial AP, my lord, we are plaintiff in the lower court.
What, dismissed?
No, my lord, order was in our favor, for the.
What is this?
Want to recover the money amount, we've also filed release application before the trial court, and for the respondent in this, my lord.
You are respondent here?
Yes, my lord, yes, respondent.
Notice issued? You
Yes.
file your wakalat?
Yes, please.
What have you filed then?
In the lower court, we have filed release application for the recovery of the amount.
Then
which
what happened?
The respondent have, they have come here and filed the stay of the commercial appeal.
Here,
Yes, my lord.
there is a stay of that order
Yeah.
for the release of the amount.
Yes, my
And what have you filed?
lord. We have filed an affidavit and IA for the release of the amount as well.
You file an early hearing.
Yes.
Early hearing application, notify the other side.
Okay.
Okay, then file an application, not memo.
Okay.
But you must serve the other side.
So fresh matter contempt. Honorable Honorable Single Judge has
Take it,
given.
ma'am, that take it.
My lords, contempt fresh matter, my lords.
Take that also. Call the rest.
Serial number 1, Shruti and Rajeshwar.
My lord, I appear on behalf of the
Yes, Mr. Raghu.
appellant. My lord, I am in a very piquant situation, my lord. The order was passed third, and it has not yet been uploaded. I don't have a copy of the order. But in the meantime, on the basis, my lord, that the order of temporary injunction has been vacated, the status quo order was
You are
there.
there, Mr. Chin.
I appear for the
The
respondent in
status
this
quo
matter.
order was there during the pendency of the proceedings.
I want to file my objections in this matter.
Let the status quo continue, my lord. Let not, because the whole dispute, my lord, is centers around two camps saying that they are entitled to run and manage the school. But the fact of the matter is that we have been managing it for long, and now, my lord, they are saying, no, you have no right to continue to manage the school. Maybe they are right, maybe I am wrong, maybe I am right, maybe they are wrong. But I don't have the benefit of a recent order of the court, my lord, because it has not yet been uploaded. So, my lord, my respectful request to your lordship is, let the status quo order which was there till the order was passed on the 3rd of July continue till I am able to get a certified copy of the order and file it before your lordship. So, Lord, we have the benefit of seeing the reasons which have weighed with the court to vacate the status quo order.
This is 1 under this section, arbitration. What was the prayer made in that, Mr. Raghavan, in your section 9?
My lord, in the section 9, my lord, the prayer was, my lord, we just passing on to your lordship, sir. My lord, the prayer, my lord, was that there should be an interim measure of protection, restraining the respondent, their agents, servants, henchmen, etc., from interfering with the petitioner's operation, management, and running of the schools. That was my prayer. And a status quo order was granted.
No.
Admitted position, my lord, is that I was running the school prior to all these problems started, which prompted me to come before the court seeking for protection. Status quo order was granted. Now that status quo order, my lord, has now been dissolved by virtue of an order passed on 3rd of July. My lord, I don't have the benefit of an order of the court, and the reason why, my lord, I am making these submissions before your lordships, my lord, is kindly see one memo that I want to file with a photograph. Now, what has happened, my lord, is on the basis of this vacation of the status quo order. Please see page number 23, my lord, if your lordships are kind enough, that memo that we have filed today. They come to the school, my lord, and saying the status quo order is over, and then disturbing the running of the school. My lord, there are about 600 children.
350 children in the school, my lord. Let not, and schools have commenced, as your lordships are aware. Let not things be disturbed now.
Yes.
Ultimately, my lord, it's a question of, and that we were running the school, we were operating the school till the dispute started, not in dispute. Now, my lord, there is a dispute with respect to one MOU that was entered into between the parties. My lord, that, of course, my lord, I do not have the benefit of seeing the order of the trial court. My lord, what has weighed with the court, I don't know. And in any event, my lord, that's a matter to be decided.
But tell us one thing, the 15, the order at 15, page 15.
My lord, yes, my lord. Yes.
Is not the order?
That's the order, my lord.
That's
This is the order sheet.
This order sheet.
That is the order sheet granting, no, my lord, that is the order sheet granting status quo during the pendency.
No, no, no. This is the
Dismissed.
No, this is what is dismissed, my lord. We don't have the order.
But there is a detailed order.
Oh, yes, ma'am. Yes, ma'am. It has not been uploaded yet. Yes, my lord. I'm sorry, I didn't notice that. This is the, where the.
Are we saying that there are two orders?
No, my lord, this is in the order sheet.
The order sheet.
Order sheet.
Only the extract of the order is mentioned in the order sheet. But the main order comes.
IA number so and so allowed, IA number so and so dismissed. As my lords are fully aware. Operative.
What do you say, Mr. Chief?
There's a big difference in what's happened, my lord. There are 3 proceedings filed. One original suit filed by them in Mysore for the same relief. One original suit filed in Mysore for the same relief of injunction.
And what is the arbitration clause say? Which is the seat of arbitration?
Bangalore. But they file a suit first in Mysore, don't get an injunction. Then another manager files a suit on the same relief in Mysore again of that entity. Then, my lord, once they don't get an interim order, they come and file a commercial arbitration application here. In the commercial arbitration application, they ask for the same relief. They don't get the relief ex parte. We appear, my lord, we file certain memos. Court then says at one point in time, without any reasons, maintain status quo. There is an order of maintenance of status quo. Ultimately, the application is rejected by the court. That, my lord, is the order before your lordships. Who is he, my lord, is a real question. I am the owner of the school. The affiliation stands in my name. They, my lord, are an operator of a school. They are appointed only for the purpose of operating the school.
Operating mean day-to-day operation.
They are actually, my lord, they run and manage the school to some extent. But the school is owned by us because the affiliation is with us. So what they do is, they issue a notice to us, and that, my lord, is very critical. They issue a notice terminating the agreement. They issue the notice, not us first. They issue a notice terminating the agreement, and then subsequently take a stand that they are entitled to continue and manage the school as if they have a right over the property. And say, now I have a right over the property, you can't evict me except in accordance with law. My respectful submission, Lord, is he's not even a licensee in respect to the property.
Evict you in what sense?
I can't evict.
Not sense.
They
are physically there. They are operating day-to-day functioning of the school.
No, Lord, how it works in my humble submission is we make certain appointments, and all the money that is collected has to actually come into the trust bank account. So what initially happened was
Your bank account.
My bank account. What originally happened was, and this is what I must point out to your lordships, they, after the agreement was signed, did not put any money into the bank account. They started putting everything into their bank account. Then we filed an arbitration application, and an interim order was granted in our favor, restraining them from putting any money into their bank account. But they continued doing it, basically siphoned off all the money from the school.
What happened to that dispute?
That is pending, and there is a contempt application pending in that proceeding against them, where because of the violation of the interim order, and not against which they came and filed an appeal before this honorable court in an MFA which is pending. There no stay was granted, and that is pending as is. Then that is for one particular school called Geetanjali School in Bangalore, but part of the memorandum of agreement. Then he issues a notice of termination. I want your lordships kindly to see that memo of termination. Once you terminate, are you in a position? And I want to point out to your lordships, other than this, there are writ petitions filed by them, one way or the other, to take control over the school. As a matter of fact, one has been just reserved for orders on Friday. On Friday, my lord, another matter they filed saying CBSE should take action against us with respect to this school, because they say that we are running it for profitable purposes and not for charitable purposes and all of that. And in that, my lord, we have placed all the records to show as to how the process of the court has been completely violated. Then they filed one more writ petition before this learned single judge for a same relief with respect to another school called Geetanjali School. Then when the matter was heard, they finally withdrew it. There's an order I must place before your lordship that as well. Then they file writ petitions for police protection before your lordships. At least there are 2 writ petitions of police protection that have been filed, which ultimately they said in respect to one school, only students will be protected, not the rival parties. Today, he is nobody. It is not as if he is one group of trustees, my lord, who's fighting against another group of trustees. He is simply a manager of the school who's supposed to run the school. That contract has been terminated. Please see, I think the paperwork, my lord, they have filed.
What is the effect of interim relief being rejected?
The effect is, my lord,
You will work out your disputes.
we will have to work out our disputes in any way. But the point is, in their claim or in the application under section 9, they said they have a claim for money. Their claim was for 20 crores. Please see the prayer, my lord. As a matter of fact, the specific in the application that they filed, the commercial arbitration application at page 73
Paper book, na?
in the paper book. May I humbly request, my lord, to look at page 87
Paper books.
in the paper book, my lord, and I think the paper book has been handed over by them to your lordships now.
The effect of the status quo was they were operating the school.
That is disputed, my lord. We are not admitting to the fact that they were operating the school. We never said that they were operating the school.
No, in terms of the MOU. Very
No,
well.
the MOA was terminated long back.
Okay. So when was the MOU terminated?
24.
24th of
15th July 2024.
terminated.
Terminated by them.
So then what is the effect of status quo?
The effect of status quo, I'll continue managing.
Whatever is the status quo.
Whatever the
prevailing-
status quo as in
prevailing
today will
on that
continue.
day.
Yes.
Is it your case from 15/7/24 you have been operating?
Yes. Our case is.
No, my lord, on the contrary, I showed your lordship the statement of objections to the section 9.
That's their case, Mr. Raghu.
I know, I bowed down.
Please see the relief.
I am
my
sorry,
lord.
my lord.
No, no,
Please
it's
see
all-
page 87, para 39. March. March. Yeah. Oh, I think, my lord, after the termination in March, it was taken over. In March, after the academic year. Please see para 39. About a few lines from the bottom, my lord. In the arbitration, petitioner would be claiming amount spent and loss caused to the petitioner because of interference in management operations school, as also illegal demands made and terminations effected without complying with the obligations of respondents under memorandum of agreement. Quantification loss is yet to take place. Petitioner is certain that the sum would exceed 20 crores. His claim is for money. And then, please see his termination, Lord, which is.
But just one, Mr. Raghavan, you accept the fact that you gave a termination notice.
My lord, it is true, my lord, that the termination notice has been given, but that termination notice has to be read in entirety. Then I showed your lordship, because there is one sentence that is picked out from that notice to say that, but if we read the whole notice, my lord, it has a different color and
No,
perspective.
but the notice
Entirely
is
terminated.
to.
They have terminated it, my lord. They have terminated.
Have
it.
not terminated.
According to me, my lord, that agreement does not, that notice does not amount to termination in the sense in which my learned friend is
Please
placing it
see
before your lordship.
page 25. Lord. Please see page 25, notice of termination. Para 24 at page 33. Your para 24. Your clients are hereby informed and copies of this reply are marked to them, as also the other trustees for information and needful action, that the MOA dated 11/12/23 stands cancelled. I'm sorry, page 33.
Yeah, we have seen
Stands
that.
cancelled and the termination of trusteeship of third addressee from Gita's education is of no consequence. More so when nothing transpired on the date of the alleged termination of the trusteeship except as entry. Very clear termination, Lord, and this has never been withdrawn. Nor have they taken a position that this is not a termination. And we've said so in our objections that we pointed out repeatedly.
Now, the prayer made in section 9.
Yes.
Mr. Raghavan, now let's see those prayers.
I think I should place before your lordship, before I do that, there are two suits. The two suits where an identical prayer has been asked for with respect to this very school. I'll place that on record, but I want to place those suits on record before your lordship. Comment said they've taken this.
I mentioned.
You file any legal statement, who filed the suit, they have filed.
They filed.
We
the
filed
suit.
section 9, man.
No, no, they filed a suit first.
Oh,
in
that,
Mysore.
yeah, yes, we filed it.
First suit in Mysore.
But it is not against these people.
For the same injunction. No, no, sir, same person.
Please see para 46 at page 90,
I'll
we have
produce the
disclosed
plaint,
it.
my lord.
We have disclosed it.
I'll place the plaint. I'll place the plaint. I want to place the plaint. Ah. It'll have an impact. It'll have an impact.
Please
It
see
also
page
shows,
90, my lord. We have disclosed those suits and we have told the
but the
court
plaint is
what are
not
those.
there. Plaint is not
Plaint
there.
is not there, of
Ah,
course.
I'll place
I-
the plaint. I'll place the plaint. I'll show your lordships the reliefs. The reliefs are identical.
Who are the parties?
The party-
Different.
No, no, they're not different, sir.
They're
They're
different.
not
Please
different.
see para 46, my lord.
Let's have those documents.
Yes, ma'am. I'll place them.
My lord, in the meantime, let status quo continue, my lord. Let not there, my lord, status quo is, I have been running the school. Admit, and I showed your lordships from the state. Why should they come and disturb the school?
It's your case, termination effective 24.
Yes.
In your case, that you have to forward thereafter.
Yes. Yes.
Status go out, status go. But
No,
in
the
your case,
problem is every order is being misinterpreted, and then they go to the police with that order and tell the police, we've got this order from the court, now come and protect us. Every single time,
when will you file the claim?
I'll file tomorrow itself, no difficulty. Tomorrow or day after your lordship.
My lord, please see the memo for a minute, my lord. My lord, I have no objection, my lord, but the children, every
Children are
day
not
they
affected,
create
no?
problems.
It's our
Every
school.
day they
It
create
is our
problems.
school.
My
It's our
lord,
school.
naturally, my lord, they kindly see what has happened, my lord, at page number 23 of the memo. Please see, my lord, for a minute.
It's not filed along with this.
Because they have nothing to do with this. We have disclosed the, we have
As a
disclosed
matter
it.
of fact,
It
Lord,
was
yesterday,
not their
they
case.
have called the teachers.
It was not their case in the section 9 court that those plaints have any relevance,
Of
nothing.
course it is. Of course it is. As a matter
Then
of
they
fact,
could have filed it there.
it was, we have pointed it out. I'm sorry. You don't find the claims there. Who's paying the salaries for the teachers, the classrooms?
Can I detain your losses one more minute, my lord? Please see page 23, and with that, I would have nothing more to say. Please see page 23 of the memo that we have filed. My lord, if I ask myself the question, do we want this situation to continue? Even for one day? Kindly see page 23, my lord.
23 of the claim.
Of the, no, my lord, of the memo that we have filed today. This is with respect to the school in Mysore. My lord, that is one of the respondents.
Yes.
And-
These are photographs.
Yes, one of the respondents. And my lord, kindly see, my lord, if your lordship will kindly turn to how, please see page 25, my lord, for a minute. This is the situation, and they stand in front of the gate and then prevent children, prevent parents, prevent teachers. My lord, this is the difficulty, all because
As a-
the status quo order has been vacated.
You will agree ultimately the interest of the children.
Yes, my lord.
Children are taken care of, my lord. There is no difficulty in
My lord,
that. There
this
no
is the,
difficulty.
my lord, kindly see,
They want control over the property.
we want a situation like in page 25 to continue, my
Oh,
lord.
that
I ask
thing
myself.
that's happened, my lord. You take photographs of a person with his
No,
hand
nothing
up
has happened. Then no, the status quo should not trouble my self-defense line.
Please file it. You will have it. We want to see the planes.
Very.
You want to see a termination. You say you have not terminated.
Yes.
Displeased termination. We want to see that. So what
Yes.
is the effect of termination? What is the effect of the suit on arbitration clause?
Yes. Very, Thomas, great.
Say that, you appear for whom, Mr. Chinnappa?
All respondents.
All the
All
respondents. Just say that Mr. Chinnappa.
It's a Jacob Alexander.
Say, appears on advance notice, appears for the respondents, aviators.
But there's only one protection, which I think is in the interest of the school, and it is not going to affect, and in fact, it is in the interest of both the parties, I think, Lord. Let not either party precipitate any matter.
No,
We are
please
going to
don't say
police,
anything
all
more.
this, which my learned friend said, let not my client do it, let him not do it, let us leave it at that.
You also said the interest of the children is freedom.
Yes.
He also said.
Yes, they don't precipitate matters.
We'll
So they
take care
don't
of
go
the
to the
children,
police.
Lord.
My lord, my
We don't
learned
need
friend
them
is
to
right,
take care
my
of
lord.
the
My
children.
learned friend is right
They
there.
are taking care of the children.
Let us
It's
not-
our school.
Don't
An operator
precipitate
can't
by
take
going
over
to
the school
police and
tomorrow.
all that.
Sorry.
The request of Mr. Chinnappa to File certain documents, re-notify. Yeah.
Great.
Only Mr. Rameshwar and you also, whatever you have filed the memo, you must file it in the registry also. We have now handed, we keep it with us, but we must file it in the registry.
Lordship, posting tomorrow, tomorrow, day after, no?
Yeah.
Day after. The order of the, in the order may be directed to be released, my lord. So that if your lordships can consider that, it will be beneficial to everybody.
Lord, as a matter of fact, I must point out one thing. I've just been informed.
Again.
They have called all the teachers and asked them to leave the school.
No, my lord.
Yes,
No,
as a matter-
that is
teachers are
committing
present before the
suicide. That is
court.
they are what they are
No,
doing.
no.
They are doing,
Their
that is our
teachers have
allegation.
come here and they've received calls from them saying for the months of January to March, where they were allowed having some control, they've not paid their salaries. So they've said, if you don't resign now,
No, who
we
is
will
in
not pay
control then,
salaries.
my lord? Who is in
Teachers are there.
control?
Teachers are there.
Who is in control then?
January to March, sir.
The 25, you said 24, you have taken over.
January
Well,
to March.
where
I said
is this,
specifically till March, and I corrected myself. Huh? January to March, not they were there because not the
25.
year had to be
The
completed.
termination according to him is July 24. Then who are running the school, my lord, from
That is
July
because
24?
Now, my lord, the teachers have been specifically are here.
No, my lord, why
Yes,
would
sir,
I want to
teachers
commit
are there
suicide?
before the school court? Teachers are before the court. Right.
That order copy, lordship, consider directing, upload.
Know what is the position there. We will just see, you make your effort.
We will.
Everything, then you place it.
Yes, I am sure, my lord, by today it should be uploaded. We will. After argument, it should be done.
See, I don't know what is the process here. You need to mention it before the learned judge, you must mention it before the learned judge.
My learned friend has mentioned. We'll do it, my lord. We'll do it again. We'll do it again. We'll do it again.
The meantime, all these objections.
Serial number 2. Bishop Naik.
For the petitioners in this case, my lord, there are minor office objections raised with regards to the PIL. If notice may kindly be issued, my lord, during the, please, my lord, there are minor office objections. We are NOC, we have filed NOC wakalat, my lord. We'll file it, we'll comply with it during the course of this week itself. During the course of this week, my lord. Yes, my lord. My lord, if a date may be fixed in this matter, my lord. Very well, my lords. Much obliged.
16/7.
Much obliged, my lord.
Serial number 3. Srimati Purnima.
Number 4, my lord.
2 weeks time may be granted for complying of the object. Much.
One 8. Serial number 4. Shri Narendra Kumar.
Yes.
My lord, this is a public interest litigation regarding a scam, my lord. Properties have been seized and Honorable Special Court has directed to be sold off. But a few properties are encroached upon and people are constructed buildings over there, my lord. I had filed a memo on 20. Yes, my lord.
What is this recalling of order of 16?
My lord, I have, there were some accusations saying that I release videos and so on. I'm an NGO and I have to cater to around 1 lakh depositors. So however, I have to release videos on that. So Honorable Court had directed me to deposit 5 lakh rupees as to prove my bona fides. And the videos, the transcript of videos were false, my lord. This is a fake video. It's a doctored video. So I have requested that my that money may be returned to me. That's all, my lord. Maybe returned to me, my lord. Yes, my lord. That was a recall, my lord.
May I submit, my lords?
Yes.
What's the allegation of the petitioner? Not there is there are several scams, my lords, and under the provisions of KPIDFE Act, my lords, the Protection of Interest of Depositors Act, the Honorable Special Court, my lord, passes the orders making the ad interim attachments as absolute. Subsequent to which, my lord, I am under a direction that I should be auctioning the properties and realize and distribute it, my lord. Several matters are pending before, my lords, this honorable court, where, my lords, there was an implicit dispute between, my lords, the enforcement directorate, my lords, and the KPID. The enforcement directorate saying, my lords, that they being a central enactment, they will have, my lords, the first charge over the properties. Now, my lords, the honorable Supreme Court, it is well settled. But during the proceedings, I filed an application saying that this is not as much a public interest litigation as much as it is a publicity interest litigation or litigation with extraneous considerations. But here is a petitioner who says he's working in the interest and for the depositors who lost the mill. But I appear for the competent authorities, my lord, under the provisions of KPIDFE Act, my lords.
Respondent number 35, my lord. There are around 19 companies, my lord. They have submitted.
Allegations.
Are these completed respondents notified?
Yes, my lord. All have been. This is a 6-year-old case, my lord. My lord, around 1 lakh people have lost money. For last 7 years, no action has been taken, my lord. It's very slow, painfully slow, my lord. And the properties are slowly being encroached upon and sold off.
As far as the encroachment is concerned, my lords,
I have filed a memo with the photographs, my lord.
I have, my lords, I have a limitation because, my lords, I do not have the police machinery or the law enforcing machinery. I have written, my lords, to the officers concerned, my lords, and I have been reminding, and my lords, I have been following it up. That, my lords, I do admit. There is some sort of an encroachment.
Matter 4.1, my lord. Yes. I appear for petition. Initially, the petition was filed by me, my lord. Original petition first was filed by me, my lord. Subsequently, my learned friend, party in person, series of petitions.
For 4.2 also.
I am only concerned with the society, my lord, respondent number 3. What had happened, my lord, is that there was an interim report from the registrar of societies regarding the society. Large-scale diversions have taken place in the society to its sister concerns. Thereby, there was asset liability mismanagement in the society. Society could not honor the matured deposits, my lord. No action was taken. At that time, I knocked at the doors of this court by filing a PIL. Subsequently, the matter from time to time, the orders have been passed by this honorable court. Competent authority has been appointed. Now the competent authority is seized with the matter, my lord. At that juncture, my lord, my learned friend, with respect to the other sister organizations, he has filed petition. as far as in my case is concerned, only forensic audit has to happen. And after initially the interim report of the registrar was there. Subsequently, the final report indicts the officers of the society. Under surcharge proceedings has to be taken against the directors of the society, because you have swindled the properties of the society into the personal names.
My lord,
My lord, it is.
please.
My lord.
No, I have not clear. As a matter of fact, my lords, the surcharge proceedings may not arise at this point of time, because once, my lords, the provisions of the KPIDFE Act are invoked, my lords, there is a scheme provided under the PIDFE Act, my lord. First, my lords, the government, my lords, issues a 3-2 notification. It may be, my lords, a suo moto or on a source information or on a complaint based, my lords. Because this called the Karnataka Protection of Interest of Depositors Act, Lord. But every state except the state of Assam has got its own PIDFE Act, Lord, which are almost pari materia, my lords. So now, my lords, the special court is fully functional. Orders have been passed. We have been implementing the orders, but there are several matters pending before this honorable court. If the petitioner were to, my lords, say,
My lord, if I may. Yes, they have been changed. Yes, ma'am. Yes, my lord, I have gone checked 2 times, my lord. I have done it. Yes, my lord. I have given an English translation, my lord. Yes, ma'am. I have, yes, miss. Yes, my lord. Yes, my lord. I have done.
States that he has carried out the analysis of section with regard to translation of the Kannada.
Yes, ma'am. My lord, just.
What is this non-filing of amended petition? Mr. You have to tell.
It's been filed, my lord.
You have filed it also. Even the counsel appearing for the petition for the petitioner in 8746/2020 states that the amended petition has been filed. The registry will report on this aspect as well. There are certain objections which are there. Just please kindly look into.
I will look into it. I will look into it.
Please notify.
My lord, just one request, my lord. My lord, there are 1 lakh people waiting for deposit of 5,000 crore for last 7 years, my lord. There is a painfully slow.
Only you have to take action.
Yes,
and
ma'am.
ensure recovery of that money.
Yes,
Please,
ma'am.
ma'am.
Yes, ma'am.
Please,
And
ma'am.
distribution, my lord.
So as far as-
In fact, my lord, I have been requesting them to inform the depositors whether their claims have been accepted or not. Even that has not been happening last 6 years, my lord. Respondent number
But
11.
I have
My
filed.
lord,
In this matter, my lord, the government issues, my lord, an ad interim attachment, my lords, a provisional attachment notification. But I have to go to the honorable special court and get the same made absolute. Once it is made absolute, my lords, I have to recover the properties, auction them, and redistribute them. Plus, there are several developments in several financial establishments. Lord, several matters pending before this honorable court. I am one in opinion with the petitioner party in person that there has to be some degree of urgency. But I cannot prevail over the orders of this honorable court. I can come before your lordship, stand with a folded hand and say that the matter may be taken upon priority.
my lord,
There are writ petitions pending, my lords. Not before this honorable court, my lord, but my lord, the honorable courts are taking it. The honorable courts are taking it. But to say, my lords, that he should be given the first priority, my lords, it is. I may not be able to have a say in that matter.
Priority, my lord.
As a matter of fact, my lord, we have been taking on the litigation with the enforcement directorate, with the PMLA authorities, with the SURFACE authorities, because there are several questions of law, my lords. Same properties. My learned friend is saying that we're not taken any action, so that may not be true.
My lord, there are two.
Please, my lord, in fact, my lord, action taken report has been filed, my lords, but I'll go down, I'll file another one.
1 year back.
My lord, 3 or 4 action taken reports have been filed. The last one, my lord,
23/7/24, my lord.
So is there any requirement to file a further report?
They have not done anything after that. If they,
May I make one humble submission? Let it be taken on record. Let the statement made that I have done nothing be taken on record, my lords. It is so very easy to make allegations, my lord.
Has some aspects in it.
My lords. Please, my lord, please, my lord.
That is why I am saying, what is the progress you are making?
I will file. I will file, my lords. I will file, my
my lord, one respondent, number 11, they submitted around 8,000 claims in 2019 February. 6.5 years almost, my lord. They don't know what happened to the.
When are you filing the status?
What's a fortnight from today, please, my lord?
Pardon?
A fortnight from today, please, my lord. I will file, my lords,
Say the counsel for the, for which,
for all the competent authorities. All the competent authorities, my lord. All the competent authorities.
all the competent
Yes.
authorities state that the status report shall be filed within how much?
15 days from today, please, my lord.
Within 2 weeks from.
Today.
Within 15 days.
Please, my lord.
We notify this.
May I make one humble submission, my lord?
Give a copy to.
Please,
Yes,
no.
ma'am.
Please, no, please. No. But one humble submission. The application, whether at all this is a genuine PIL is pending consideration. I have placed
No,
the,
my lord.
whether at all this PIL is the real PIL, my lords, I have filed an application and seeking dismissal. Well, that may be kindly considered. Please, my lord. In fact, it's only because of that application,
That was
such
with
an
a
order has come to be passed.
fabricated video transcript, my lord. I have submitted a rejoinder on 13/4.
Press that application, you will look at.
Please.
28.
Obliged, please.
28/8,
Obliged, please.
serial number 5.
My lords, item 5, my lords, pertains to the encroachment of lakes in the Hubli-Dharwad region. My lords, pursuant to your lordship's order, my lords, they have filed a status report of the DC. My lords, I don't have a complete copy of that report, though now, my lords, we will sort it out. My lords, I'm seeking some time to file my response to that, my lords, 2 weeks' time.
Yes, who has filed the statement? What have you said, Mr. Banga?
My lords, the DC, my lords, has filed pursuant to your lordship's order of 1912, my lords, 24. They have filed a report, my lords, on the status of the 5 lakes. My lords, the state, my lords.
Just give him a copy.
Yes, yes, he has. I'm not disputing it. I'm not disputing it. I'm not disputing it. I'll sort it out, my lords. I'm not disputing it. My lords, I'll need to file my objections also to that one. Right. Great. My lords, giving any date? Any date?
29/8, serial number 6.
My lords, I beg to represent, my lord, the appellant, my lord, in 6.1. And my lord, respondent number 6 in my lord 6.2 and 6.3. Lord, these are all the matters, my lord, which are connected to other contempt petitions which my lordships were pleased to, my lord.
These are similar to the one which had come the other day,
Yes,
Mr.
yes, my lord, precisely, yes. All those are posted, my lord, on 14th of August. My lords may kindly club with that, and my lord, it may also be kindly taken on 14th. Similar
But
questions are involved.
tell us what orders need to be passed in here, except the fact that you have filed an appeal.
My lord, my appeal is only arising out of one matter, my lord, where an order by the learned single judge was passed without issuing notice to me. Only that is, my lord, the scope of the appeal.
But what is see what is the order of the learned single judge to complete the
learned
process in
single-
10 months?
Yes, my lord. The learned single judge, my lord, kindly directed for, my lord, the implementation of the orders of RERA by the Revenue Recovery Authority. And this
But
order,
how
my
are
lord,
you,
though I was
Mr. Shamsundar? How is that affecting you? It says so.
Precisely not, my lord. In fact, my lord, just because I was not, my lord, this was passed, my lord, without issuing notice to me, the scope of the writ appeal is only so much. I would rather, my lord, oppose the contempt petition, my lord, contempt petition directly, my lord. It may not make any difference, my lord. The writ appeal may not.
Tell us what can be the grievance that you have not been heard when the order is only to complete the process in 3 months.
I fully bow down, my lord. It is for the sake of procedural formality, my lord. This writ petition was filed because, my lord.
You mean to say that it should not be completed within 3 months?
No, my lord. It is only for the procedural formality. In fact, my lord, I have my lords may kindly recall, my lord. I have one common submission to make in all these, my lord, contempt petitions. My lord, the contempt petitions may be, my lord, I don't dispute that, my lord, the Honorable Court may not have jurisdiction, my lord, the Honorable Court has jurisdiction, but overall, my lord, all these contempt petitions, my lord, are with respect to, my lord, implementation of the orders passed by RERA. My lord, the RERA Act is a complete legislation in itself. The section 40 of the RERA Act, my lord, gives complete jurisdiction to the very RERA authority to even, my lord, take all those steps, including contempt. Therefore, my lord, somewhat, my lord, I feel that we are, my lord, somewhere overburdening the Honorable Contempt Court because the RERA authority has this jurisdiction vested in.
But what difference it would make either RERA or the Tehsildar who has initiated the execution? It doesn't make any difference.
The Tehsildar, my lord, has initiated execution at the instance of RERA. Now, my lord, the petitioners, instead of going, the contempt petitioners, my lord, instead of going before RERA and having a complaint that the orders forwarded by the RERA authority to the Tehsildars are not being implemented properly, they would directly come before this Honorable Court and
But you have not come against that order. Neither you have challenged the authority of the RERA to say so that the Tehsildar will initiate it. Your grievance is against the order of the single judge. That's all.
Precisely in one of the writ petitions, my lord, we got such a direction. We came before this Honorable Court in the writ petition where certain orders were forwarded to the Revenue Recovery Authority. The Revenue Recovery Authority, without following the process and procedure, my lord, went against us. We came before this Honorable Court and this Honorable Court permitted us to raise all these, my lord, before the RERA, my lord, the Revenue Recovery Authorities, where we have even filed our objections saying that please report it back to the RERA, not to the Honorable High Court. Because, my lord, 226 jurisdiction, my lord, I don't know why, my lord, it's being overused. Lord, I'll place.
But that's not the subject matter of your appeal, Mr. Shyam Sundar.
Certainly not, my lord. My lord, my appeal in this matter.
Should be going to it.
Yes, my lord, my appeal is only for procedural purpose, my lord. In this appeal, my lord, I have not raised it that question.
So the parties will work out before the Tehsildar. Will work it out before Tehsildar. You may have objections. You may tell the Tehsildar whatever you have said before us on that day.
Certainly, my lord. We are free, my lord. We are good to go. We are good to go before the Tehsildar and, my lord, place all our, my lord, grievances. That we may be relegated, my lord. The writ appeal could be disposed of.
Is there any?
I am appearing for the contesting
order.
Yes, my lord, respondent.
No, is there any interim order?
Lord, in fact, my lord, he has filed an undertaking affidavit before the bench that he will settle the dues in 2024. The lordship may kindly see his undertaking affidavit for a moment. In the contempt petition number 909 of 2023 at page number 5, annexure 4. And now,
yes, 909.
Yes, my lord. 909 of 2023. Annexure 4 is his affidavit. Have extra copy. Right, should I pass on?
Just state that.
Madam, Lordship may kindly take para 5, my lord. Para 5 of that order, the affidavit, it starts at 5 and relevant paragraphs are para 5. Para 7, my lord, at page number 7. That's regarding the writ petitions order and para 9. And subsequently at para page number 9, my lord. Para 11, my lord, I am very sorry. Para 11 would be relevant. May I read, my lord? In fact, he has not challenged the orders of RERA. The present writ
He has not challenged. That's
Yes.
what we have put it to him. But the only thing is now you have to work it out before the Tehsildar.
Now much water has flown by way of this undertaking. Now he wants to deviate. My lord, his only grievance in the writ appeal is that he was not given an opportunity. And if at all an opportunity was given before the learned single judge, he would have gained time. Now, more and above that, he has gained time both of 2 years now. Now we are in 25.
Now this is only in 909 that this undertaking is there.
Yeah, in 321 also he has filed an undertaking to that.
Yes, we have filed
Yes.
it. Yes, Mr. Shyam
But I
Sundar,
am
how would
relying
you
upon
answer
some
that?
judgments also, if your lordship permits me, my lord, on that.
How would you answer an undertaking given to the court that you will implement the order of the RERA?
My lord, I have only one single answer for that, my lord. Of course, my lord, certainly I cannot drift away from the undertaking, my lord. In fact, my lord, may kindly recall, my lord, there is an intervening moratorium, my lord. That is the showstopper. That's the reason, my lord, I beg your lordships, my lord, leave to place the moratorium orders. Otherwise, my lord, in fact, we have had, my lord, repeated meetings with the home buyers. And my lord, we have been contesting the petitions, my lord, before the NCLT. My lord, if we are through with the NCLT, my lord, absolutely there is nothing
No.
that should come in our way, my lord, to settle the dues.
We want to put it this way.
Greatly.
Forget those litigations which are going on. Forget the moratorium.
My lord.
The fact that you have given an undertaking to ensure compliance, how would you ensure the compliance? Tell us one thing. Divorce, what is happening in other courts, NCLT or everywhere? How would you ensure your affidavit where you have given an undertaking is complied with?
My lord, I shall place a detailed affidavit to that effect.
Pardon?
I shall place an affidavit to that effect. I would, my lords, may kindly record this, my lord. I shall place an affidavit, my lord, in a day or two.
Show that affidavit.
My lords, on 1/4/2024, they file affidavit before this court and convince the court that they will be making substantial payment. Thereby, on 18/4, this honorable court has directed them, ordered them to pay a sum of 4 crore rupees. And a partial payment has also been received by us. They have paid us a partial amount.
How much you have received?
To the tune of 1.5 crores. My lords.
The rest of the remainder could not be paid, my lord, because the IRP came in picture. The IRP is controlling.
Undertaking.
Undertaking, my lords, at page number 10,
We are in
internal page number 6.
909.
909. There is
Which page? Internal page 6?
There is an affidavit filed on 1/4/2024. My lord.
That's
Can you
right.
please, yes. So in that there is at page number 10, internal para numbers, page number 6, para number 10. So they have given a table in which they have said that order amount in contempt 11 crores and change, order amount refund with the exit 9.5. So here they say 26th April 2024 they are willing to pay 1.5 crore. 26th May 2024 they are willing to pay 1.5 crores. As per the order of the RERA. They have given a detailed chart, my lords. And at the next page, at para number 10, there is a chart.
They have not complied with it.
They have not complied, and thereafter, this honorable court has on 18/4/2024 have asked them to deposit 4 crore rupees for not complying with this order. That also is not been adhered to.
Yes, Mr.
May I, my lord? May I just make two submissions? I am thankful to my learned friend Renaud that, my lord, he said that partially, my lord, the undertaking was complied. Then, my lord, what comes in picture in between is, my lord, a petition filed by none other than them, my lord, before the NCLT. My lord, therein, my lord, an IRP comes in between, an interim resolution professional, my lord, in respect of Vasudevan Satyamurthy. He takes over all the affairs. Then, my lord, another very important eventuality happens. There is a split between the customers, my lord. One cross section of the customers, my lord, wants to come sit with us, settle, my lord. They have had several meetings and we have drawn minutes. My lord, I will place it before the Honorable Court. Second part of the customers, my lord, they would want to, my lord, go ahead, my lord, with this kind of coercive process. My lord, all these things, my lord, in between, ED comes. My lord, Enforcement Directorate comes. My lord, Enforcement Directorate wanted to, my lord, hold an inquiry, which I submitted, my lord, last time to your lordship's kind concern. My lord, another cross section of the customers, my lord, would go before the special court for KPID, file a criminal case, my lord, initiate KPID process against us. My lord, it's from multiple angles, my lord. They are trying to stop the show by their own indulgences, my lord. That's what is the major, my lord, thing that is coming in the way of, my lord, we settling the matter. My lord, the SBI granted additional funds to us by way of, my lord, a scheme with which we could complete, my lord, a monitored construction and hand over them the flats and also settle all the dues. And my lord, by the time SBI could release the funds for the purpose of completion, they file objections, my lord, stall the entire funds. There are too many things, my lord, that are happening, my lord, which are not being kept before the Honorable Court. There are certainly no willful disobedience, my lord. The undertakings have been given, the undertakings have been, my lord, partially complied. My lord, all these intervening factors, my lord, are disturbing, my lord, the settlement of the issues. My lord, kindly allow me, my lord, 3 or 4 days time, I will place a detailed affidavit.
You will take, we are only concerned with this undertaking given. See, you can't take it lightly, your own undertaking.
Certainly not, my lord.
Once an undertaking has been given, it should be taken to its logical end.
My lord, I'll, my lord, say on that in a separate affidavit, a detailed affidavit, my lord. I'll also, my lord, place my assurances how best, my lord, I am going to keep up my words, which are, my lord, which I have, my lord, committed to understand. But I'll certainly not break. I'll certainly not break.
Makes is some part of you are proceeding under the KPID. Some of you are proceeding.
In fact, my lord, I would like to defer.
PMLA. And some of you are here.
It is true, my lord. It is true that only we have approached the RERA, we have obtained an order. And to enforce, to precipitate it, my lord, we approached this court by way of writ petition, and writ petition was without going into the merit.
There are multiple remedies which are there, but all those simultaneously.
But all that has also been stayed.
My lord, I would like to defer with what the senior counsel has argued, that we have approached multiple forums. We are not doing any forum shopping, my lords. We have only gone to RERA, and thereby we have come for the. We have not gone to NCLT, my lords.
He says, with regard to this company, there are pending litigation. There is a moratorium. There is an NCLT. There is an NCLAT. Everything is being there.
Please,
my lord, I will place a detailed affidavit, a proof of that before this honorable, my lord.
In fact, he has mortgaged the very same property.
Just 1 minute. The submission of the petitioners in the contempt petition being 909 and 32124 is primarily that despite an undertaking given to this court by way of an affidavit, the respondent number 6 in both the writ petitions have not complied the said undertakings. So they do concede that a part of the amount which was reflected in the affidavit has been paid.
Lords, the undertaking is only with respect to CCC 909 and not in others.
Okay, don't say 321, 390. You concede that part of the payment as per the undertaking has been made, the balance has not been made. The balance is still forthcoming. Mr. Shah, senior counsel appearing for the respondent number 6 company, state that who is the gentleman who has to file? The managing director. The authorized representative.
Vasudevan Satyamurthy.
Managing director shall file an affidavit. Now we are recording this, Mr. Shamsundar, that you will file an affidavit giving the timelines for making the balance payment.
Greatly obliged, man. Greatly obliged.
Giving the timelines to make the balance payment as per the affidavit filed on 1/4/2024. 1/4/24. Mr. The
My
affidavit.
lords, may kindly also allow me to, my lord, explain, my lord. Besides, my lord, giving the
Them
timeline,
also
kindly allow me to explain, my lord.
It was bona fide.
Lordship, may I submit a few things, Lordships? I'm appearing for some of the contempt petitioners. Lordship,
Let's hear one by one. What did you say, Mr. Shyamsundar?
My lords, may kindly also, besides, allow me to explain, my lord. That's it, my lord. I'll give the timelines and besides explaining, my lord, what has caused, my lord, this.
We are concerned with your timeline. We are not concerned with anything. We are concerned with this undertaking which you have given should be
Greatly
implemented
obliged.
letter and spirit. That's all.
Great. Great.
This is an endeavor towards that. That's all. Now
Lordship,
tell us what you want to say.
Lordships, if I may. Lordship, this undertaking was given 2 years prior. Lordship may record in the orders that they have given various undertakings that we will pay. But for 2 years, they have not done. Lordship may ask them to file number one, a payment or schedule, and number two, they should also file an undertaking for contempt 321 because they are still under contempt after not even filing after not even complying of it. 321, they should file a undertaking.
The authorized representative oblique managing director of that's also respondent number 6.
Correct.
Just see the other one.
Vasudevan.
321, my lord, the next contempt.
Vasudevan
There is no
Satyamurthy.
undertaking. It may kindly be, my lord, posted along with the other matters, my
No,
lord, which is
they
scheduled
should.
on 2025 because there is no undertaking in that.
They should file an undertaking when we are in contempt.
Respondent number 5 shall file an affidavit on the compliance sought by the petitioners of the orders passed by the RERA.
Passed by RERA.
Correct. Correct.
Orders passed by the RERA. The affidavit shall be filed within 3 weeks. To stop re-notify this contempt petition and the appeal. What do you say on appeal, Mr. Shyamsundar?
Appeal, my lords, may kindly, my lord, it could be, my lord, held along with the otherwise, my lord, I may have to be relegated to, my lord, take all my contentions before the Revenue Recovery Authority.
Mr. Shyamsundar shall also take instructions. Take instructions as to whether the appellant intends to pursue the appeal, in as much as the challenge is only to the order of the learned single judge, whereby the learned single judge has directed the
Implementation of order.
Directed implementation of the order passed by the
RERA.
Within a period of 3 months. Within a period of 3 months. Where is that order?
Page number 285, notes.
Okay. Re-notify.
Lordship, there's one more submission. Lordship, there's an affidavit that has been filed by the Tehsildar in December 2024, where they have identified some lands which have to be auctioned. And they gave 7 days of time to Ozone to reply back. Either they can auction it. They have not replied back, and Lordship may kindly direct the Tehsildar to auction those lands. They have identified 12 properties.
We will look into it.
My lord said serial.
That's ultimately a direction given by the learned single judge to the Tehsildar. So anything has to be worked out, it has to be before Tehsildar. We are only concerned with the contempt and the appeal filed by them. That's all.
Correct.
Serial number 16, the same matter persists and the same order may be passed in that.
Lordships.
No, my lord, in respect of serial number, my lord, contempt petition 321, my lord.
121-247.
There is no affidavit that was filed, my lord, which my lords may kindly keep it as it is, my lord. Will my lord have our say in the matter. The affidavit of undertaking, my lord, is filed only in CCC 909.
Serial number 16.
Just 16. Just re-notify on the same date.
1215.
With respect to respondent number 5, my lords.
Correct.
The same orders may be passed.
Lordship, in 1215 also, the undertaking should be given because again they are in contempt since past 2 years.
See this in item 16, you will repeat that 321 order. No, CCC 321, that would be in 16.
May make one humble submission. But your lordship may also direct them, my lord, to deposit or bring a demand draft on favor of RERA. Lord, otherwise, my lord, because this will be the second time that they are filing and undertaking affidavit before this court. Lordship may direct them.
No, no, we will not. One undertaking is enough. We are only asking them to give the timelines. That's all. Affidavit, we have said so in 321.
You say that demand draft.
Past 2 years.
For the draft, there should be
Under the,
something.
yes, under the disguise of the writ
Or
appeal.
if it is not there, what you will
Under
do?
the disguise of writ appeal, my lord, they have gained 2 years time.
Lordship, I concur with my senior that a draft should be brought in 909 for compliance.
No, not in this. The other one. Did we say anything under the other? The second part. In 320. Now in 60, 121. He is seeking a compliance affidavit.
My lords, a humble submission, serial number 6.1, they have already given a timeline. They have already given an affidavit. So let them on the next hearing day, let them come up with some bona fide payment, my lords. I am not against.
Those timelines have gone.
Please,
Lordships.
They have gone.
Please.
We are asking them the timelines to ensure the compliance.
Please, my lords, I
We are
bow down.
conscious what has been urged. There is so much of litigation. This cannot be.
Please.
There is a moratorium. It can't be acted upon everything. But we are concerned those undertakings which have been given, though there may be a moratorium, though he may have a difficulty, this undertaking must be taken to logical end.
Please.
That is
Correct, Lordship.
the intent.
In fact, moratorium, they have obtained an order of stay before this court.
They've obtained a stay from this court itself.
There is a stay of moratorium also.
Yes,
Please,
my
there
lord,
is a stay, my lords.
They have obtained it themselves, a stay. There is no moratorium now.
Oh, thank you. Next.
Greatly obliged.
What is the next notified date, Court Master?
14th
August. Mr. Shyam.
Much obliged.
Mr. Shyam Sundar, which is the date? You remember?
14th
August. 14th August.
14th August.
14th of August.
Have it on 14th August.
Please.
Greatly obliged. Greatly
Much
obliged.
obliged.
I'm coming from Madurai.
Other neighbors are also there.
I'll
Please.
come much.
That's right.
Neighbors.
Seven.
Here is the amicus courts. This is the matter pertaining, my lords, to the safety of the Krishnaraj Sagar Dam in Mysore. Lordships have issued directions, my lords, that no mining activity or allied activity shall be permitted within 20 kilometers of the dam. Now, per your lordships' last order, my lords, the state was to respond with a commitment, my lords, on how long the dam safety committee would need so as to carry out, my lords, its study on the safety of any allied activities by a trial blasting mechanism that the Indian Institute of Science would coordinate on. That is the stage before your lordships.
Who the Institute of Science? Who has sought 1 year? Thereafter, for to consider. No. Let's see the report. The memo.
So, Lordship, see page 3 of this memo.
Lad, I have not been given the memo.
Yeah, just give him a copy, please.
Lad, in fact, my lad, I don't know why the amicus and the state government, my lad, kindly see the order of my lad.
Let's first see this. Please. Let's see what do they say.
May I make a submission on?
Yes.
Please. Lords, on the timeline, of course, I leave it to your lordships. But there is one fundamental aspect, notes, which is that these communications have come from the Dam Safety Organization. Now, your lordship see at the top of page 3, Office of the Chief Engineer, Dam Safety Organization. There are two authorities contemplated at the state level under the National Dam Safety Act. One is the Dam Safety Committee, which is under section 11. It seems to be a high powered and a technical committee. Then there is the organization under 14. Now, all directions made by this honorable court in these proceedings are for the Dam Safety Committee to take a decision. Now, the state has placed, Lords, a communication from the organization.
What is the status of this organization?
Lords, it is constituted under section 14. But the powers and functions, my lords, are vested in the committee under section 11 onwards. Now, my learned friend, my lords, for the petitioner is appearing in respect of certain individuals. The matter has been converted to a public interest litigation. And therefore, as the amicus, my duty, my lords, is to place this, that this honorable court had directed the committee to, my lords, take into account all applications of private parties, see if their quarrying activities would in fact impact the dam safety in any way, whether the vibration is such that it could affect, my lords, or cause danger. Now, in serial number 61 before your lordships is a private writ filed by, my lords, one of the private parties, ostensibly placing, my lords, the permission granted to them. But that permission also comes from this organization, not from the Dam Safety Committee. And this honorable court in its order of 19/11/2024 held, firstly, the committee must meet. It's a statutory committee, my lords. There must be minutes, etc. Secondly, the orders of the committee could only be given effect to once placed before your lordships and once those orders received, my lords, the imprimatur of this honorable court. So at this stage, my lords, the state would also have to clarify before your lordships how this organization is taking the lead, whether the committee has met, committee's minutes, and the impact on the so-called permissions to the private parties.
May I just?
Yes, well.
Yes.
This is an organization created under the section 14 of a particular act.
The committee does not really come under it, my lords. Just see 11.
Where is the organization? There is a establishment of state dam safety organization.
That is under 14.
That's under 14.
Please see 11. State Committee on Dam Safety.
No, but that's what they are saying, that this would now come under the committee comes under the organization.
I don't know where my friend is getting that from.
No, if you see, just see section 11.
Because
you see section 11.
Yes, my lords. I'm on 11, lords. That's the composition of the state committee. It's a multi-member body. Now, the directions of this honorable court are to the committee.
Very well. No, but since a stand has been taken by the organization, will it not in the same subsume that this is basically a call of the committee as well?
That would then have to be borne out from the minutes. The act does not seem to suggest that. The act contemplates two authorities with different functions bestowed on them. As far as the committee is concerned,
we can put it to them. Now, ma'am, tell us one thing. Now, though organization has written a letter, now this gentleman who has written the letter for organization is the chief engineer. Now, whether the chief engineer is part of the committee?
In fact, my lords, third schedule makes it clear. It's the other way around. Just see the third schedule to the act, my lords. Functions of the State Committee on Dam Safety. Please see item 2 therein, to review the work done by the State Dam Safety Organization. So the organization is subordinate to the committee, not, therefore it changes the entire.
No, where is the committee review the work done by the committee? These are functions of the state committee.
Yes.
So the state committee would also supervise the working of the organization. Now, what is being said by the amicus is that this letter is by organization, not by the committee.
No, but the committee is the one, then I will seek a clarification whether the committee has recommended has written to the organization, my lord, with regard to this.
No, it's, if you see the third schedule,
Yes, I saw that.
functions of the state committee on dam safety.
Yes.
2 is review the work done by the dam organization.
Yes.
So it appears that the committee is something, has a supervisory role over the organization as well. So the organization has given a letter, whether this stand of the organization has been approved by the committee. What do you say?
Milord, your lordships kindly see the order of this court, Milord, on 8/1/2024. Milord, this court, Milord, prohibited the conduct of quarrying operation by using blasting material within radius of 20 kilometers, Milord. Now, the undertaking given to the court was, Milord, that the Kaveri Jalavan Limited has approached the central agencies for conducting the trial blast, Milord. Then the trial blast was conducted. There was an opposition from the farmers and therefore they postponed it. On the last date of hearing, the government advocate said that instead of the central agencies, we'll approach the Indian Institute of Science. Your lordship granted time today to take up the matter. Now they say is 1 year.
No, just
Milord,
1 minute.
Indian Institute of Science has no expertise to conduct this at all, Milord. There are number of agencies, Milord, of the central government, National Institute of Rock Mechanics. They have already conducted the trial.
No, 1 minute, just 1 minute. But tell us one thing, ma'am, how does the Indian Institute of Science has come in?
Milord, they have no expertise to do this, Milord. In fact, before the division bench, Milord, they suggested, Milord, CIMFR Dhanbad, that will be the agency they will undertake. They paid them the fees of 25 lakh rupees. They came for conducting the trial blast. There were some issues of farmers. Deputy Commissioner failed to provide protection and they went away. Now, to overcome, Milord, the series of orders passed by this court, Milord, now they are taken up the plea that no, we'll refer it to Indian Institute of Science. Indian Institute of Science, Milord, doesn't have the expertise to conduct the trial blast. Milord, the trial blast is, Milord, they will put a hole and, Milord, different cases, varieties of blasting are put and measured, Milord. Kindly see the order at paragraph 4, Milord, of the order dated 8/1/2024, Milord. Milord, so far as the learned amicus objection is concerned, Milord, there are series of orders passed by this honorable court directing the dam safety organization to consider whether the conduct of crushing operation will affect the safety of the dam. So those orders, Milord, which are already become the final, they are sought to be reviewed by the learned amicus in this
My friend may not have read the order of 1911, Milords.
I have read the order.
Show the order of 1911, since my friend is making this pointed submission. Please see para 6 as to who is to decide, Milords.
Milord, I want your
It's
lordship
convenient to
kindly see-
conflate the organization with the committee, but I am, Milords, reading from the order. Please come to para 6 of the order of 1911-2024, which sets out all the previous orders passed in these proceedings. Please come to para 6, Milords. Thus, the committee took the view that since the present proceedings are pending, the representations of the private parties could not be considered. It is to be observed and clarified in the above regard that the pendency of the present petition shall not come in the way of the committee to deal with and decide the individual representations which may be received by the committee. On the contrary, the committee is expected to go into the individual cases, take its own decision, to be intimated and placed on the record of this court such decision. The order dated so and so passed by the division bench of this court in Machama Devi Stone Crushers versus State in so and so is brought to the notice of the committee, in which also the court has made observations and required the committee to take into consideration the various aspects which may be raised by the private parties and take its decision. It is again clarified that if any individual case or application is put before the committee shall go to the facts of such case individually and take decision. And 6.4, my lords, is important. Such decision, however, shall be placed on the record of the present proceedings before it could take effect.
But tell us, Mr. Sundi, who has to now take this study?
This statutory committee, my lords.
Not IIC, Indian Institute.
IISc, the state must explain to your lordships how they have been chosen as the nodal. I have no say on that. I have no say on that.
See, this is what has come from you on the last date, that Indian Institute of Science would submit the Indian is undertaking the scientific study to assess the impact of blasting within a radius.
Correct. Question is, when dam safety committee is there, why did you go to Indian Institute of Science? We didn't say. No, this court didn't say that you should go to the Indian Institute of Science.
They came forward when we sought for information from other bigger institutions, they could make a study and submit a report. So the Indian Institute.
Then with the report of the Indian Institute of Science, you will go to the dam safety committee.
It will go to the organization.
No. Dam safety organization has written a letter to the Indian Institute of Science as per your letter which you have produced. Now let us assume that the Indian Institute of Science will give a report.
Yes.
Now with that report, whether you will go to the committee.
But it has to be placed before the committee.
No, we want to know now whether you have taken a decision to approach the Indian Institute of Science to undertake the committee,
The Indian Institute of Science came forward to conduct the study because none of the other institutions from throughout.
Will the Indian Institute, does the Indian Institute of Science have the competency to undertake this study?
Yes, that's the reason why they came forward. And please, the letter of the executive engineer, and their letter also.
Lords, may I suggest this? The committee statutorily is required to meet at least twice a year. Now there have to be minutes of these meetings. The state, that's the starting point.
No. Are you saying that the committee authorizing Indian Institute of Science to undertake the study?
Must be minuted.
Must be.
You're
right. You're right. It can't be at a lower level. It has to be at a committee.
Quite so. And especially in light of your lordship's directions. Not only is it a statutory function, now it is acting, lords, per your lordship's directions. And because of the gravity of the matter. Therefore, those minutes would be the starting point in my respectful submission for the state to then take the matter forward.
Appointing Indian Institute. This is the thing. Now she has filed a communication from dam safety organization, enclosing therewith the from the styles. She should file on the proceedings on the dam
There is one set of minutes on your lordship's record placed by the state, my lords, which was as of 12/7/2024. It's almost a year now. There, as my friend rightly submitted, the request was to that agency from Dhanbad to come and carry out this initial investigation. The minutes record, my lords, that this CSIR, CIMFR Dhanbad came down, my lords, on 25/7/22, but due to rainy weather, the trial blast could not be conducted. So that was the status as of 22, reported in July 24. Now, between July 24 and June 25 or July 25, the committee ought to have met at least twice. Those minutes, my lords, the state would have to place.
So what you are saying is now instead of CMFRI, that's institute under CSIR.
That's right.
Now it has been given to IIC.
Whether that has been minuted and decided, my lords, by the committee or not.
Ask them to file the minutes.
Please, that would in fact be the starting
We'll
point.
file the minutes. Just say that on the last date of hearing, this court had passed the following order. First of, we have recorded the submission of learned AJA that it is the Indian Institute of Science which is undertaking the scientific studies to assess the impact of blasting within a radius of 20 kilometers. First of, today the learner comes, AGA has filed a memo enclosing therewith a communication dated 1st July 25 from the address to her from the Dam Safety Organization, which has also enclosed a communication from the concerned department of the Indian Institute of Science. Full stop. Indian Institute of Science, wherein the Indian Institute of Science where do they say that it is 1 year? Full stop. Just say this. We say nothing. The said letters are self-speaking. Full stop. Appropriate shall be. We don't. Madam, we will first look into this. It would be Indian Institute of Science or CMFRI. And we want those minutes to be between what is the date, Mr. Sondi?
12/7/2024.
No, but by the time IIC had not come in picture?
No.
No, when was CMFRI was appointed?
Somewhere in 22, it seems.
Who had appointed?
This committee had called upon them.
Yes.
If you'll, I just read
This
it.
court, my lord, in 8/11/2024 order, that they said that they will approach the CSIR, CMFR, Dhanbad. Paragraph 4 of the order of this court, my lord, dated 8/1/2024, my lord.
Just say that Mr. Sondi, learned amicus, has also drawn our attention to the order dated
1911.
1911
24.
24. No, 8/1/24 also.
That's the initial order, my lords. What I read to
There,
your
my lord,
lordships was
para 4, my
1911.
lord, this court, they said that they will approach the CSIR, CMFR, Dhanbad. Para 4 and 5 of the order dated 8/1/2024. and that has been approved by the Dam Safety Committee. Once the trial blast is conducted.
Wherein in 8124 reference has been made in paragraph 5 thereof that that CSIR-CIMFR was requested to conduct scientific study. Now this scientific study is on the dam.
No, well, it's a ground vibration of blasting. Scientific study of the blasting and its consequent ground vibration.
Full stop. Vide letter dated 25/5/2021. Full stop. When did you take this decision to engage Indian Institute of Science? Any idea? Now today, Mr. Sondi, you are saying that now CSIR, CMFR is not in picture for scientific study.
That's the inference we are drawing from this communication. As per the minutes, my lords, their scientists did come down on 25/7/22, but due to the monsoon, apparently the trial blast could not be conducted, which only means it is deferred till such time the climate permits. Now, whether the committee in fact resolved, my lords, to replace this CIMFR with Indian Institute of Science, and on what basis, only the state can, my lords, submit.
Next page, it's highlighted portion.
It says CMFR has submitted its report also. If you see the paragraph 5 of 8124, in view of the recommendation of CSIR, visited the KRS dam premises to conduct experimental blast and submitted its report. Deputy Commissioner then Mandya has banned the blasting activities.
That is the trial blasting that is awaited.
That's right.
That is awaited. And it seems, my lords, that certain members who attended this meeting of 12/7/2024 were also from the IISc. Now they may be, my lords, expert invitees. So their opinions are certainly there. But that is quite different from appointing the IISc as that nodal agency to carry out this. That's an expert decision, my lords. The committee has to make that good.
Page 28, I think they have directed CISL to conduct trial.
A plea has been advanced on behalf of the counsel for the petitioner that the state must clarify whether it is the IISC is undertaking the scientific study or the CSIR, MFR. Full stop.
And for completion, I may just point out, notes in the last part of these minutes, which are along with the IA that the state has filed.
Where is that?
That is an IA for extension. IA number. What is the IA number? This was an extension IA filed by the state on 14/11/24. At page 92,
just show us.
IA 8 of 2024. Lordships get these minutes at page 67. Please come to page 92, my lords. The opinion of these representatives from IISc is recorded, my lords. Lordship C, para A, B, and C are the views of the three IISc members, which opine, my lords, that the possible damage that could be caused to the reservoir can be estimated through the mathematical simulation and validating using the parameters of explosion. Then at para D, a scientist from CSIR, my lords, who attended the meeting online, submitted that the CSIR CIMFR, which is involved in the above process, have information by data on this strata of area around KRS dam, which can be utilized for validation of mathematical modeling. He also agreed to carry out the modeling through proper validation. And this was then the final resolution. Chairman, after considering all the above options and discussions, directed the Chief Engineer Irrigation Mysore to contact CSIR CIMFR for submitting a detailed analysis through mathematical modeling and proper validation. Then, my lords, the analysis reports submitted by CSIR CIMFR may be vetted by a subcommittee bar group comprising experts from IISc and or reputed institutions for onward submission to SCDS for taking a decision. So this was the flow in July 24. First, Dhanbad carries out this modeling, makes a report, then a suitable subcommittee, either of IISc or some other agency, vets it, places it before the state committee, who takes a decision. Now, whether all of this has transpired, whether the report has come, committee has seen it, resolved indeed to appoint IISc or somebody else, must be, my lords, answered.
Does not this reflect ultimately the final supervision is Dhanbad?
Yes. Quite so.
Only a subcommittee.
Quite so, quite so. The principal report is of Dhanbad. No doubt.
And I may just place on record subsequent development, Millard. They paid the fees to CSIR. They came for the trial blast conducting this the scientific study. There were some farmer organizations, they protested saying that this trial blast shall not be completed. But that committee sought protection from the deputy commissioner, police protection should be given to them. They refused to provide police protection. They went back, Millard. This is the state, Millard, where, Millard, your lordship's orders are not implemented by the state. They failed to provide protection to CSIR.
Just cut the last one. We'll ask you to place on record the minutes. The minutes.
From 12/7/24 till date, my lords. And if your lordships are inclined, maybe this Dhanbad institution could also be implemented here, lords, if your lordships think fit.
Look, they are only expert committee or experts who are assisting the dam safety committee.
Quite so, quite so. Quite so, my lords. They are not binding on the committee.
If they encounter any problem, like he says that farmers are stopping, etc., then it is ultimately the committee will direct the dam safety organization or the concerned authorities of the state to look into the matter and provide that safety, etc., is provided to them.
What, Mr. Sondi, there is another aspect of it, another perspective. Now, this IIC is only a subcommittee. And what was the impression we got on the last day was it is the IISc which is looking into this dam safety. Maybe analysis done by CMFRI, then given to the IISc for having a look. That's the impression. That's
vetting.
what.
Yes. Vetting is what.
Vetting is being done. It appears your instruction are also maybe IISc, but IISc jurisdiction is only on vetting, nothing more.
CIMFR is the authority, nodal authority, or the person who is with expertise. And for the studies which are taken by CIMFR, whether it is on the proper lines or not, the academic support is
quite
provided by the
as a subcommittee. It's hardly the last word on it.
Yes, exactly.
It's not the ultimate committee to look into it. The impression is that now IIC is looking into the dam safety.
Let it like this, my lord, it conducts, my lord. It
Just say that our attention has been drawn to the minutes of the meeting held on 12/7/2000. Minutes of the meeting of the State Committee on Dam Safety, wherein with regard to item number 23, the following has been stated. Page 92, 93, tick to tick. Okay, now this subcommittee would also from IISc then submit then analysis submitted by this may be vetted for onward submission of SCDS.
That is the state committee for
State Committee for
Dam
Dam
Safety.
Safety.
Yes.
For taking a decision on the matter.
Quite.
That's the ultimate decision.
Lordships.
By the committee.
Please.
First, the following has been stated 92, 93, tick to tick. Then a counsel for the learned AGA shall take instructions as what action has been taken pursuant to the minutes of 12/7/2024. So she shall also file the minutes of the meeting if any held after 12/7/24. How much time, ma'am? See, it appears CMFRI, Indian Institute of Science Analysis has a subcommittee, then the Dam Safety Committee. It's not the Indian Institute of Science is not actually studying the dam safety. It's only analyzing what CMFRI has said. And CMFRI has said only with regard to there is there is a terminology used. Not fitting. This is experimental.
experiment, gra-
Does it say experimental?
study of ground vibration.
Seismic work. Seismic.
Experimental trial blast is the phrase.
Trial blast. You're right. Trial blast. So that study they have done it. Then the subcommittee. Then the
committee's final decision. When Lordship said meeting, it should be meetings. As per your Lordship's direction, they were to meet twice a year. It's the mandate.
Let's see if there is meeting also. Then we'll talk of meetings. When will you file it? Okay. Let's after 3 weeks. When you will get cleared yourself, not IIC, it appears what Mr. Sondhi has pointed out is only as a subcommittee, not as a final, taking a decision on the dam safety. The dam safety is a statutory body. It needs to be taken by the statutory body.
That is a different.
One.
So it's very unfair for you to ask him what is this.
Mr. Sodhi, tell us one thing. Now, ultimately, on any dam safety in the state, is this committee?
Quite so.
On any dam with regard to in the state, anywhere within the state, the ultimate body is the dam safety committee, which has to give its opinion.
That's right, Manoj. There is a classification there under the Act which refers to the phrase specified dam. So I do not think it is omnibus.
Oh, is it so?
I'll just have to examine because the matter pertained only to KRS. But my lords, the sense I get is that
there are dam safety units, etc., etc.
That's right.
That this dam safety organization looks after day-to-day affairs. But that committee supervises, it is ultimately, it is a dam safety organization, which is the one which is in the ground, headed by the chief engineer, which is the officer, and assisted by a host of officers working in
to answer your lordship's question, as far as the committee is concerned, my lords, it seems to be for all dams, whereas the organization under 16 is confined to specified dams. And specified dams is defined, my lords, under section 4 Roman 10 to mean a certain specified type of dam, my lords, which has a particular height, built, which is constructed before or after the commencement of the Act, but which is 15 meters in height, satisfies the conditions which are quite specific.
But the organization will come in for this KRS dam?
It may not, my lords. This is where I'm before your lordships to plead.
I'm very sorry, my lord.
That the, no,
the
sir,
KRS
please, I
dam,
have to.
1 minute.
Yes, I'm sorry.
I am not taking any issue. It's not adversarial. The committee is, my lords, the statutory supervisory body. It is not restricted in respect of specified dams. Then comes this organization, which is clearly subordinate. It has some role to discharge, which is subject to the supervision. Now, under 16, the Dam Safety Committee is in respect of all specified dams. I am, my lords, technically, I'm not in a position to state whether, my lords, KRS is indeed a specified dam or not, because there are certain technical parameters there. But in respect of all dams otherwise, it is the committee. So it is the omnibus umbrella organization. And this is where, my lords, serial number 61 comes in. I know my friend will say that the amicus has no role there, and I'm in your lordship's hands. But the permission there is not from the committee. It's from this organization. And that is not what was contemplated by this honorable court in all its orders.
Your lordship, when here 61, I will place on record Dam Safety Committee, my lord. What the Lord amicus is saying is totally incorrect. Dam Safety Committee, my lord, is only to supervise the whole thing. Kindly see the powers, my lord, have been Dam Safety Organization. This is the day-to-day. Yes.
Now, madam, just tell us, before this letter was issued to you by the organization, was it placed before the committee?
And in response to my lord's question,
Not required to place, my lord, for
there is also, I'm grateful to my colleague, there is, my lords, another classification which is called distress condition. That is under 4I, which is distress condition means the occurrence or potential development of such conditions in the dam or appurtenant structure or its reservoir, etc., which if left unattended to may impede the safe operation of the dam for its intended benefit, or may pose serious risk to the life and property of people and the environment, including flora, fauna, and riverine ecology. When the reference was made, my lords, to this committee, and the terms of reference are on your lordship's file, there was a review panel constituted in 2021, which opined, my lords, that the KRS dam is in the state of distress and therefore meeting the definition under 4I. So it is a far more serious classification, if I may submit, than just a specified dam. So again, that would, my lords, fall within the domain of the committee.
How would you say so? Committee's jurisdiction?
Third schedule, my lord, the functions of the Dam Safety Committee. Third schedule to that act, yes. It is not doing day-to-day activities. It's only Dam Safety Organization, my lord. It is in the forefront of day-to-day organization. It doesn't take, it is only lays down the policy decision. Kindly see third schedule to that act.
Yes, we have that.
Yes, kindly see, the functions of the State Committee on Dam Safety for the purpose of maintaining standards of dam safety, prevention of dam failure, related disaster, discharge such function as may be necessary as per the guidelines, standards, or other direction issued by the authority, review work done by the stamp safety organization, establish priorities for investigation in case of specified dams under distress condition. In case where the investigation with respect to safety of any specified dam has already been undertaken, order further investigation into the safety of such specified dam, other assigned responsibility for execution and including non-department resources, association of independent experts where necessary. Recommend appropriate measures to be taken by the safety of the specified dam which is under distress condition. Establish priorities among the projects requiring remedial safety. Review the progress of measures recommended in relation to dam safety. Assess the potential implication of reservoir filling in the specified dam in the state on any upstream state. Coordination mitigating measures with such upstreams. Assess potential implication of failure of specified dam in the state or any downstream state. Coordination with mitigation of measures with such downstreams. Assess probability of cascading dam failure. Coordinate mitigation of measures with all concerned including border states. Recommend provision of funds for the state to plan appropriately face devastation. Provide strategic supervision for such dam improvement rehabilitation programs that are executed through funding. Any other matter relating to dams which may be referred to it by the state government.
Yes.
Then, Milad, there is a dam safety organization powers are Milad at page.
Yeah, just 1 minute. You see this, Mr. Sundi, this memo she has filed.
Lordships.
That letter was written by the Indian Institute of Science.
Please.
The first paragraph says submitted, Indian Institute has submitted a project proposal to conduct scientific studies on assessing the adverse effects of the blasting at nearby quarries up to 20 kilometers from the periphery of this. The project focuses on the field in situ measurement of seismic waves. Now it appears, is it a overall scientific study? And not only as a, the minute
Vetting.
says so.
The vetting.
Minute,
Not just the vetting.
Not for vetting only.
It seems to be broader than that.
Broader than that. And possibly in place of now CSIR.
Quite so. And that can only be, my lords, known basis the subsequent decisions taken by the committee. And my friend has read to your lordships the schedule. No doubt, those are the powers, my lords, of the committee. But the organization is circumscribed, my lords, under section 16, qua only specified dams. Now, maybe the state can also clarify that, notes. The picture would be clear whether KRS is specified, notes. I personally, I do not know because it has these requirements in 10(2). It has to have a difficult foundation problem. It must have an unusual design. Now, obviously, that has to, my lords, be determined by some technical body. It cannot.
But why should we go into that?
Only because.
No, but this letter of IIC, this, it talks about only KRS dam.
Yes, yes.
They want to make a study of that.
They want to make
project as a project study. They want to do it. Maybe for academic purposes also. And
we don't know. I'm more on the source of the jurisdiction
of the committee.
Committee qua the organization. Because ultimately, my lords, if even one private party, be it a quarry or a miner, is to be permitted to carry out any activity within that radius, it must not cause the dam any danger whatsoever. And your lordships will see the matter was converted to a public interest litigation because of the seriousness. The dam, as your lordships are fully aware, regulates the entire flow of Kaveri water in the state. So now by some interpretation or misunderstanding on the part of the authorities, a subordinate committee or an organization which has no jurisdiction cannot start meting out permissions, my lords, to private parties. That's in the teeth of your lordship's order.
Very well, you file your this thing and possibly you must take instructions also, ma'am. This communication from the organization was placed before the committee. Just have it after 3 weeks.
Milad, that is different, Milad. I will, when the matter reaches, I will argue, Milad.
And if my lord could, my lord, club it along.
No, it's different, Milad.
There's another contempt petition that is filed. My lord, in CCC 33 of 2025, my lord all these matters together, the law can
Malad.
give a quietness to the entire issue.
My learned friend, my lord, on the last.
It is related.
Because what they are seeking is for crushing activity, my lord, which is coming within KRS.
Who says within 20 kilometers? You show, no, you show us that somebody is saying that it is coming within 20 kilometers, then we'll consider that.
Then the law may take the order that they have referred to, 1911-2024.
No, on the last occasion, if I remember, my pointed question was, who is saying that it is within 20 kilometers? That you have to clarify.
No, Malad, we are
That's
not
what I
using
asked.
any blasting, Malad, it's crushing operations, Malad. Wherein, Malad,
There
the
was an
crushers,
issue.
yes.
There was an issue whether it is within 20 kilometers or beyond.
Yes.
If it is within 20 kilometers, particular consequence. If it is beyond, a particular consequence would be there.
That is only in respect of quarries, Malad, not in respect of crushers, Malad.
Your submission is also, it's beyond 20 kilometers?
Well, that is about 19.5 kilometers. But the question is, Malad, no, one second. I'll just only clarify.
Now, what has
Malad.
happened, my lords, is
One
I
second,
know
I
my
think-
friend would
I
not
think-
like me intervening.
One second, Malad,
I
I'll
owe a
just.
duty as the amicus. I'm in your lordship's hands. Is that pursuant to the directions of this honorable court? This organization has taken a decision, qua this petitioner,
Not only
holding
for
that.
me, Malad, hundreds of quarries. Malad.
Both, sir. That the quarrying where, my lords, there is no blasting, etc., could be permitted is the impression I have, because I am not amicus in that case. The private parties have moved a writ in 61 for directions to implement that decision. The lordships would therefore necessarily have to consider whether the organization had the power to make that decision. Is it in the larger interests of the dam? And therefore necessarily it relates back to this PIL. I would leave it to your lordships whether they have to be.
No, we'll have it on the same day.
Please.
Malad, may I submit, Malad? That is, Malad.
We'll have it on the same day.
Malad, it's a different, your lordship. I kindly.
You are right. We are not clubbing.
Malad. Well,
We
may
are
I
not
just
clubbing.
only 1 minute, Malad. This is not only in case of petition, Malad. The Dam Safety Organization has granted permission on the orders of this honorable court, Malad, to number of persons.
We will see that. We will see that.
Malad, I have Malad, hundreds of employees I have employed. I have to pay Malad 3.5 lakh rupees minimum electricity consumption. Why only against the petitioner, Malad?
Okay. We will
If
see
that is so, Malad, they should stop all other quarrying, crushing activities, Malad. I am not quarrying, Malad. It is only a crusher where, Malad, building stone is brought from other places. Crushing activity is done. Your lordship.
Have they come on record?
Yes.
Whether this quarrying activity is within 20 or beyond 20?
Malad, it's not quarrying, Malad. It is crushing.
Very well. Crushing.
My quarry, Malad, it is beyond 20 kilometers. Crusher is beyond 20 kilometers, Malad. Okay. I don't have any quarry, Malad.
So crusher beyond 20.
Yes.
Would not be affecting the dam.
No, it will not affect because there is no, the Dam Safety Organization headed by the Chief Engineer, Joint Director of Department of Mines and Geology, as per the undertaking.
Who has to take a call?
It is only, as per the direction of this honorable court, Dam Safety Organization will have to take a call.
Right, my friend again is conflating the two.
We will look into that.
I read the order to your lordships. It said committee 10 times.
Your lordship, I kindly see 30th of July order, Malad. Kindly see order.
I'm sure that.
Kindly see 31st of July order. Kindly see order dated, Malad. The 30th of July 2024 order, Malad.
There would be minutes.
Yes.
No, 1 minute. There would be minutes of this letter from Indian Institute of Science must have been placed before the committee. Just take instruction from the officer. It was placed before the committee. Then there would be minutes also, approval minutes. You will file that also.
Your Lordship kindly see the order dated 31st of July, that's clarifies, my lord. 31st of July 2024 order. Kindly see, my lord, the 6.2, my lord, page 5. my lord. The order dated 28/3/2004 passed by the division bench of this court in Manchamma Devisi so and so is brought to the notice of the committee, which also the court has made observation required the committee to take into consideration various aspects which may be raised by the private parties and take its decision. It is again clarified that if individual case or application is put forth the committee shall go into the facts case individually and take a decision. Such decision, however, shall be placed on record for the proceeding before the court, before it court take effect. Then decision which may be taken by the committee in respect of individual cases shall take effect after the approval of this court. At this, their learned government advocate invited our contents of the minutes of the meeting dated referred to above to highlight that the committee has now decided to undertake detailed analysis through mathematical modeling and proper valuation. This is that this court directed the committee to receive individual decisions and take a decisions in the matter.
So it does not say organization. I'm at the cost of repeating myself.
Committee doesn't meet, committee is then referred to in that.
That's a different ground. But it's not a case of organization to take a call. The court is very clear.
In that case, committee will have to take a decision.
Yes, very right.
We have represented to the committee. Committee has that. Committee doesn't meet, it misses once or twice.
And this is the court is referring to in your case only.
Yes, yes. That this court directed you approach the dam safety committee. The dam safety committee will decide.
You have represented?
Yes, we gave a representation.
What are your instructions on this?
Order is passed on 24th of November. In my connected case.
Right. We will ask them. That's right. Now we have got it, the connection. Now tell us, what is your stand in that contempt?
They have filed an affidavit.
It appears contempt is violation of this, not following this. Now what is your stand?
Contempt is not following the order dated 19/11/2024.
They have filed an affidavit, this court saying that I have not conducted any crushing operation.
19/11/2024. Let's see that 19/11 is there.
And the complainant therein.
Now, what is the order direction in that matter? In that order?
The committee would hear the parties and take a decision.
That's right. So it's ultimately that order is following the earlier order.
Quite so. It all comes back to
the committee.
Yes, my lords.
What is your stand now on the committee? Did the committee take a decision? You're getting the point, no? Very well. You must have filed any affidavit also in the. Okay, we will have it the same day.
Please.
Same day.
I'm the very same organization Millard has granted, and then Millard.
We will not go on that discrimination plea. We will go what has been said, what has been done. Then we will see whether compliance has been made or not.
Otherwise, let them take a decision, Millard. When you lordship consider, Millard.
You're right. She doesn't able to say, ma'am. Can you say you have taken a call decision?
Annexure J have produced before the court.
Okay. Just show us that 61. This
Well, it refers to the Annexure J, Millard, page 57. Your lordship may kindly see.
Just 1 minute.
Yes.
So it is your case also. Your case need to be considered in terms of 31/7/24 order.
Millard, Dam Safety Committee itself has taken a decision which has been extracted in that. Annexure J, Millard, page 57, Millard, in 61, Millard, in the writ petition.
Page?
My lord, page 58, your lordship may kindly come to, my lord. Your lordship got it. Second paragraph. The representation received above placed before the first special meeting of the State Committee on Dam Safety in Karnataka held on 26/11/2000
So 58.
for deliberation. Yes.
58.
Yes.
Annexure H.
Yes, annexure J, my lord. Page, it starts at page 57.
This is in your petition?
Yes, in my petition, my lord.
But we have 58 is your representation.
I'm sorry, yes.
H1.
Only one. My lord, I'm sorry, page 64, my lord. Kindly come to page
Yes,
65, my lord.
22nd November.
There is a
24.
general decision taken by the committee, my lord. The representation received above placed before the first special committee, State Committee on Dam Safety in Karnataka on 26/11/2024 for deliberation and consideration. The committee examined the representation as noted. The chairman of SCDSC, after taking views, opinion from all the members, opined that the activity does not involve blasting, as it is not a mining activity. The petitioner is not carrying out the crushing activity by procuring raw material from the legal mining quarries with the mining mineral dispatch permits issued by the Department of Mines and Geology, as explained by the Joint Director of Mines and Geology. After detailed case-to-case deliberation and categorical examination of the facts in accordance with law, considering the opinion of all the members along with the members of the officials from the Mines and Geology Department, opine that Dam Safety Committee itself has taken a decision, that to permit crushers who don't use the plastic materials. Based on this decision,
what is the final conclusion in this communication?
In this case, I am permitted to carry on crushing operation without using any blasting material.
Then why did you file this writ petition?
But I have not been permitted despite the decision of the committee.
That's the grievance.
Yes.
Oh. Ma'am, have you taken a stand on this in the writ petition? What he's saying is the committee itself has taken a decision where there is no blasting, the permission need to be granted, something like that.
We were not going to take the order dated 19/11/2024, 6.5.
No blasting activity should be ignored. See the chairman after taking this of the moment though, it does not involve blasting, as it is not a mining activity. Also, crushing. No blasting activity. So, but there is no blasting activity. If it is not blasting activity, then this mining crushing activity is carried out in the crushing unit. And the legal mining process, just monitoring of the company has to be. Beyond 3 depth of the mining is furious. What? Okay.
This.
Please see the order. Paragraph 1.
No, you have filed the counter in this?
Taken no, my lord. Thrice he has taken time, my lord.
No, we don't see any connection between them.
Please take my lord's order dated 8/1/2024, 19835 of 2020, 19835 of 2023, which is before my lord. Paragraph 1.
Which order you said?
8/1/2024. Paragraph 1.
Yes. Read it.
All mining licenses, leases comprising any area, whether in private land, government land, or otherwise, that lie within a radius of 20 kilometers from the territory of KRS Dam and hereby kept under suspended animation, and as a consequence, no mining of allied activities can be carried on or continued by any person of the agency till after the decision is taken by the statutory committee constituted under the provisions of the
Yeah, just 1 minute.
Right, there is an order, your lordship may kindly see annexure G, my lord.
We will hear you. We
Yes.
will hear you in length. Let's see what are the effect of the orders which have been passed by this court. Maybe in this PIL also.
Well,
and
not-
in-
There is one aspect,
Well,
right,
one
which I must
second.
bring
That
to
order
your
has been modified by your lordships on 31st of July 2024.
We will look into that. We look into that. We will go through all the orders which have been passed in
Well,
the.
just
Because your lordship said directed on 1911, no doubt the committee will take a decision, and my friend is right, that qua his activity, the committee prima facie seems to have said there is no risk. But in 6.4 and 6.5 of your lordship's order of 1911, the decision shall be placed on record of these
for our
proceedings,
approval.
and the decision which may be taken by the committee in respect of individual cases shall take effect only after the approval of this court.
We have seen that.
Lordships.
that has been modified subsequently, my lord, on 31st. Kindly see page 55 of my petition. Page 55 of my
Modified to on what terms?
modified, my lord, saying that, my lord, dam safety can take a decision in the matter. And then subsequently, my lord, there
So
is a.
no
writ-
approval of the court need to
Yes.
be given?
I don't think so.
Kindly see, my
That's
lord,
not
this
the tenor
order,
of
my
the
lord,
order.
annexure G for a minute.
Very well. We look into
And kindly see paramount. The committee shall take into.
which annexure, which page?
My lord, page 52, my lord. This writ petition filed by the petitioner.
Huh.
This was clarified by this, the division bench. says.
Okay, division bench.
Kindly come to para 5 minute, para 9 minute.
The committee shall look and take into
Yes.
consideration all the aspects, including aspects which may be raised by the petitioner, to include the same in the report to be submitted to the state government.
Yes.
In light of all, the writ petition liable not. Where do they say that it stands modified? The
Well,
order
it is
stands modified.
31st of July order. minute. 31st of July 2024 order. Well, I read para 6.2, Millet. Para 6.2, the order dated 23/8/2005 by the division bench of this court in Manchamma Devi so is brought to the notice of the committee, which also court has made observation, required the committee to take into consideration various aspects which may be raised by the private parties, take its decision. This is an order dated 31st July 2024.
Yes, yes. Which paragraph?
Yes. Para 6.2 and 3 million.
See, they clarify if any individual case or application is put before the
The
committee.
committee shall go into the case individually, take a decision. Such decision shall be placed on record for the, only for the purpose of record, it has to be.
My
placed
friend,
before
then read the next line.
I'm sorry.
We should be fair to your lordships.
I'll read that also.
Now we're bordering on, my lords, misleading the honorable
Yes,
court.
1 minute. Yes.
6.5 and reiterated in para 4 of this
Let's
order.
be very clear. This is an order of 28 March 24.
Yes.
And this is 31/7/24.
Please.
That's right.
Yes.
In 31/7/24, at least a reading of it, it is clear that such decision, however, shall be placed on record of the present proceedings before
Yes.
it could take effect too. Now, read the next para.
Yes, Malay.
6.5, the
is taken
decision
by the
which may be
committee.
taken by the committee in respect of individual case shall take effect only after the approval of the court.
That's the reason I'm before this court, Malay.
That's right. That's a better way to say.
Yes, Malay.
But not
Yeah.
that.
Therefore, I am before this
No,
court.
no, no. 1 minute, please. 1 minute, please. We must convey ourselves.
Please.
The impression we were getting is
Yes, sir.
the order of 31/7/24 has been modified. The approval is not required from the court. That's the impression we were getting.
Yes.
You are right. And that's what you wanted to convey to us?
No, no. Now, after reading this.
Then in that case,
6.3
the application should have come in the main PIL, my lords, rather than an independent writ.
There is a further order. We would like to, Mr. Sodhi, we would like to see all the orders.
Yes, my lords.
The effect of those orders.
Please, I'll take your lordship
Okay.
through.
1911, there is an order.
That's the order I read to your lordships repeatedly.
Okay, thank you.
Great.
After 3 weeks.
Yes.
We'll have it on the same day, ma'am.
7-8.
We don't tag it. We will have it on the same. We will upload it. We'll try to upload it by tomorrow. Next.
Grateful to you.
7-8.
Great.
Yes.
This is
Serial number 8.
revival of an earlier disposed contempt petition, my lords, wherein there was a direction, my lords, for removal of encroachments and opening the village pathway. There was a direction to the state, my lords, to file an affidavit, which is yet to be filed, my lords.
You have filed your affidavit, Mr.
I'll file it in the registry. I'll serve the same now.
What do you say on this?
My lords, this is like the national highway abetting thing. It was heard substantially, my lords, at the last occasion. That's the pathway. That's the pedestrian pathway. My lordships had observed that national highway also abuts with regard to the said pathway, if my lordships were to recollect. So then we just made a submission that I did show the files also to my lordships with regard to the executive order with regard to the DC giving the permission for the change of pathway. My lordships wanted me to
Oh, yes, yes, yes.
My lordships wanted me to bring the same on record. I kept the same on record. The compliance affidavit is also ready. I'll be serving the copy also as such, my lords. A question of 100 meters of right of usage to the.
I put it to him also. Why not the, the highway is being used?
Please, that was the issue, my lords. Now, my lords, may kindly appreciate this, the pathway which is in a curved way.
Is roundabout. Highway is shorter.
I do. There's no. There
Still,
is no
we have
footpath,
went ahead.
my
We
lords.
have passed the executive order with regard to the changed pathway route so that the buildings are not disturbed, my lords. My lordships wanted.
You have got this.
Along the.
They haven't
compound
served yet.
wall of the-
Just take this,
In fact,
have a
there's-
look on this.
No, please, my lords. In fact, earlier two compliance affidavits were filed. The difficulty, my lords, is there is an encroachment by a private individual. My lords, this honorable court
tide
gave that
over the
individual an
said-
opportunity.
Encroachment into pathway you are alleging.
Please, my lords.
Now pathway has become redundant.
This
Because
path-
a national highway is there which is much
This
shorter.
pathway has become redundant for the reason that a private individual has encroached.
No. It has become redundant because there is
No,
a highway.
no, miss, the order of this honorable court, miss, the order of this honorable court in the PIL may kindly be seen.
See, you see this one.
No, miss, the order may kindly be seen, my lords.
Whether
The-
you agree that this is the pathway,
But the pathway is what is marked in red, my lords.
correct, in red, that's what
In
I'm
red.
saying,
The
showing
highway
you.
has absolutely no reference, my lords, in any of the orders passed by this honorable court.
See,
In any of the orders.
I'm not speaking of the orders, I'm speaking of the map.
That's the sketch which we have produced.
Yes, correct.
Now, my lords, what's happened is there
Whether
is
this
a
is the sketch, Google sketch or not.
which we have produced.
And
This is-
then from this end to this end, you are going by like this,
No, but
and
the-
there is a straight highway.
Please, my lords,
And how do you defend that?
the earlier, the order in the writ petition may kindly be seen.
I'm
Here.
not saying,
But
I'm on
presently-
factual matrix. Leave aside the grid petition orders, etc., etc. On factual matrix.
On the facts, on the
In a
facts, my lords,
circle, if in a circle, along the periphery is a.
the highway.
Yeah, it has
It
a
has to
more
be used.
distance,
No,
or
no.
whether the diagonal.
But the reason why the PIL came to be allowed in our favor is the milk vendors and the school children do not require to use the highway at all. The school is within the area where the residences are there. The pathway is within the area, and the milk vendors or the dairy also is within this residential area. So there is no necessity at all, my lords, for the use of the.
Just tell us what is this area? What is this area? This path?
That path has been blocked by, my lords, one of the encroachers, and there was a direction for him.
But what have you done, Mr. Chandrasekhar? Has
We
it
have
been
just,
encroached?
we have changed the pathway itself so that their needs are also
Okay, you
seen,
look
my
into
lords.
this.
Please.
That in any case, that's on the public land only.
Public land only. So what was
But what has been happening, those encroachments?
encroachments were removed, my lords. There were buildings built on the said encroachment. So what we did is, now a request was given by the person who had built the building that he is ready to give up his land so that there can be an alternate pathway. Taking his representation under consideration, the DC has exercised his power and there is a modified pathway. Subject to correction, what was I had actually brought the same to the notice of the court by handing over the original files. What was lastly submitted by the counsel for the complainant is, if what's been submitted is actually accomplished, he would be satisfied. So I have served the same on him also as of now.
Just say that learned counsel, Mr. Chandrasekhar, has handed over a copy of the
Compliance affidavit.
compliance affidavit to the learned counsel for the petitioners who seek some time to look into the same. Re-notify.
If any grievance, let them file the reply to the same as such.
Date may
Are able to.
4 weeks hence, my lords.
And look into the same and file a rejoinder if it
Please, please. But
19-8. Serial number 9, Vivek Kumar.
Number 9, appearing for the complaint, my lord. And filing memo to the effect that, my lord, order is complained. You permitted to withdraw the same as not pressed in view of the complaints, my lords, pursuant to the order. They are executed sale deed, my lord. There was a direction, now complied. Sale deed was executed. The direction was page 16. BDA shall execute sale deed, page 16.
Just say that learned counsel for the complainant has filed a memo to be signed by the complainant and him and also by him. Full stop. The memo reads as under. He reiterates the prayer for withdrawing the contempt petition. Contempt petition is dismissed as withdrawn.
Serial number 10.
If it may please my lords, I am for the petitioner. These are contempt proceedings arising out of a family matter. Unfortunately, this is the third round of litigation between these parties. I represent the father. With your lordship's permission.
She is not known yet. Yes, ma'am.
Your Lordship, there is also a contempt filed by the accused. All the matters may be clubbed together and taken up on the same date. There is a habeas corpus petition as well filed by the accused, Your Lordship.
But these are only on the visitation rights, no?
Indeed.
Yes, Your Lordship.
Visitation will continue. What is that?
Indeed.
Habeas corpus, no habeas corpus.
The complainant itself is in violation of the terms agreed
No,
between.
we will haul him for contempt there. Now today you answer this.
Yes, Your Lordship. I have already filed my apology affidavit, Your Lordship. The case.
What happened after? When did you file apology?
It is filed on 25th.
Are you getting visitation?
My lord.
Are you getting visitation today?
I am not, my lord.
When did you file apology?
25th June 2025, Your Lordship.
And how many times the visitation has been availed after you filed the apology?
Your Lordship, this case is arising out of a peculiar facts where the complainant and the accused have 4 children. Now the first child has been brought to India on a false pretenses that he will be returned to the USA or for the next academic year. Now till date, the father has illegally retained the child without any order from the court. He is himself in violation of the orders passed by the trial court, Your Lordship.
So,
Now the mother is having apprehension that if the other 3 children are sent to India, he will retain their custody, Your Lordship. And
what is the direction given of which contempt is alleged? What is the direction?
the direction given as per the Your Lordship may kindly refer to the memorandum of settlement between the parties, which is at.
Now, where is the respondent? Is she here or is she abroad?
She's abroad. All the subject matters are citizens of USA, Your Lordships.
With your permission, madam. So there were 4 children. First, we agreed on a mutual consent divorce here in Bangalore. Both husband, wife, mother and father lived here in Bangalore. Custody was joint and shared. The mother then wished to relocate to the US. A compromise was entered into on the second occasion. The relocation was accepted by the father. The mother and the 4 children relocate to the US. I, as the father, I am granted visitation rights, summer vacation custody. I exercise them. Things are good for 2 or 3 years. This issue primarily arises because of a subsequent marriage that the mother enters into. And there is some conflict between the child, the eldest child, and the new partner, the step-parent. I'm informed about this in 2024. I go to America. I meet my son. I take the issue up with the mother of the child. With her consent, I bring the eldest child to India. He's here in India now for over a year or so. Things are well. Last year in the summer holidays, the 3 children who were in America were expected to visit India to spend time with me and their eldest sibling. I make arrangements, book their tickets to travel from Boston to India. I arrange for a caretaker to travel from India to America to travel along with the children. At this juncture, the mother approaches the family court in New York to modify the arrangement entered into in India and decides not to send them. I file these contempt proceedings. I also file execution proceedings. In the execution proceedings, last year, I did not get to see my children. This year, their summer holidays are going on. Once again, the mother is directed to keep the children in India for the purpose of their summer vacation. That also is not followed. I reach out to my learned counsel and I tell her this apprehension of the mother is not well founded, that I undertake that at the conclusion of their summer vacation, I will certainly return them to the mother. I have not met with any cooperation. In these family matters, all I'm seeking is cooperation. I don't seek any punishment.
So what did you not get? What visitation you have not got?
Summer vacation, my lord. The 3 children have summer holidays right now.
Did not come because of the stay there.
There was no stay granted. In fact,
the New York court.
No, in fact, the New York court dismissed the petition for want of jurisdiction.
That was only dismissed in the April, your lordships. The primary custody was given to the mother. Vide ordered, it is filed before this honorable.
Where is the respondent?
Respondent is in the US, your lordship.
He should come to the jurisdiction of this court.
Your lordship, the subject matters, all of them are citizens of USA and all the kids are going to the school and their roots are in the USA.
We are concerned with the contemner, not the children.
With respect to the contempt, your lordship, I kindly permit your lordship, petition page number 34.
Tell us, what is the reason you have to even defend this?
Your lordship, complainant cannot benefit from his own wrongdoing.
We will look into that separately. As and when we see that, consider that, we will look into it.
The accused has not sent the children on the last occasion only because there was a primary custody granted by the New York court, your lordship, and that order has been produced before this honorable court.
Now tell us, compromise petition. Was it part of the compromise petition, the summer visitation?
Yes,
of
indeed.
The 3 children?
Indeed.
That's right.
But it does not say anywhere that the kids have to be sent to India, your lordship.
We are not on the kids, we are on the contempt.
Yes, your lordship.
Why this has been violated?
Your lordship, I kindly refer to the terms of the compromise.
Okay, just ask her to be present on the next date. We want her to be here.
Your lordship, kindly refer to the page 34, your lordship, of the petition.
Yes, as per the compromise, if the children are not sent, we want the respondent to be here.
Your lordship, the compromise terms does not say that the children have to be sent to India, your lordship. We do not have any problem if
Show us that. Show us that.
Now, the statement made by the council is true, that the petition does not mention that they should travel to India. They say that that the children spend time with their father.
We will see that. Show us.
Or you should be arranged to go there.
I am taking care of my eldest son here. The eldest child is here.
1 minute, show us.
Your lordship, page 34 of the petition, clause C.
It's only 3 weeks, my lord. If she were to send them this time, I would be happy to withdraw.
Yes, where is clause C?
Page 34 of the petition, which is filed, they have only filed the compromise terms. Clause C.
Here is clause C.
We don't have clause C at 34. Which page is
It's at
that?
page 43, please, my lord. Page 43, under the header regarding custody
The entire part of communication with the respondent.
with the respondent. The understanding is very fair. They've tried to be good to each other. Unfortunately, it's when the elder son comes to me is when the apprehension comes that all 4 children I will keep with me. So this was being abided by. Compromise petition is 2021, my
Now
lord.
tell us one thing. You were to go to US.
I did, my lord. 2021, 22,
No,
23.
The contempt is of which period?
2024, my lord.
24. Then what happened? Did you go there?
I went there in 22, 23. I had absolutely no issue.
They're asking for 24. Did you
In
go there?
24, my lord, the factual matrix changed where the elder child asked to be in my care and custody.
So did you inform her before 1 month before that? Just see this clause.
Yes, my lord. I informed her nearly 6 months before, my lord.
Okay, let's see that. Then say, unable to travel to the USA to have the children's interim custody or any part of their vacation, he shall intimate the same to the petitioner at least 1 month prior to the commencement of the vacation to enable the petitioner to make alternate arrangements.
Yes, my lord.
If the respondent visits the USA, he shall have an interim custody of the children during his stay at Lexington.
Yes.
In the even respondent relocated to. Now, where is your communication 6 months prior to the vacation?
My lord, I have from page number 71 onwards are certain screenshots of WhatsApp messages that take place between myself, the mother, and of course my assistant to coordinate the children coming to Bangalore. So what dates would be available? What are their dates of holiday? Sending which caretaker would travel to America? All these things are discussed. 1 day prior to their departure, my caretaker travels from India to America. 1 day prior to the departure, I receive an email saying I will not send the other 3 children.
Where is that?
Please, my lord. If my lord, please
Caretaker
comes
went to USA to bring the children.
Yes, to come along because they're young. So we sent somebody, a lady who has been with them when they were in India here, familiar with them. I arranged for her to travel there.
Where is that?
Screenshots of messages start at page number 71, my lord. If my lord will see, please come to page number 76, my lord. Page number 76. Third message, my lord. This is sent in January to 23. January, I have sent a message talking about travel intended in June. So well in advance, I have sought the mother's cooperation. I have received her cooperation. Kindly see, my lord, departure. Just wanted to confirm summer dates as well. Round trip Boston to Bangalore, Bangalore to Boston. Departure from Boston, June 28, departure from Bangalore, August 18th. The reply by the accused is dates and names are good. So I receive a confirmation. On receiving this confirmation, I book the tickets. The tickets are the previous annexures.
Where is the refusal?
The refusal comes by way of an email, my lord.
Where is that?
Please. If my lord could kindly come to page 89. Page 89 is an email.
What are these boarding passes?
Boarding passes are the confirmation of the tickets that I sent in respect of the children to travel from Boston to Bangalore.
You have sent the tickets also.
Yes, the tickets in fact remain open even today to be used for the children to come here. Their vacations are going on.
89. Now see this.
Please, 89. June 27th. 28th is their intended departure from Boston. I received this email stating that I have received an order from the Monroe family court and I will not be sending Anaga, Jaya and Adya to India. This is 1 day prior to departure, my lord.
What is the order of the family?
It is at the page 39 of the affidavit reply which I have filed, Your Lordship.
Then why do you give an apology?
Your Lordship, the apology affidavit was only filed due the paramount consideration. I am only concerned about the welfare of all my 4 children, Your Lordship. Now there are serious sexual allegations against the accused which came in light only during that time, due to which.
Just one. Where is that order? Respondent shall
Page
supervise,
39, Your Lordship.
have supervised visitation with the minor children. Page 39.
Page 39, Your Lordship. Ordered, the petitioner is granted primary residence of the minor children of this proceedings, Rudra, Anaga Raghava, Jayalakshmi, Adya Raghava. And it is further ordered, respondent shall supervise with the minor children until further order of this court. There is no willful violation of the terms, Your Lordship, which is why I have filed my apology affidavit.
But you say that New York court has rejected it?
It has.
It has only
Please,
rejected.
just one more.
One minute.
Right. So one aspect in this, my lord, my lord will notice in page 39, in the first part of the order, it says 4 children. The first is Rudra Raghava. Rudra Raghava is their firstborn, eldest child. He is with me. He was with me at the time of this petition. This was not brought to the notice of the family court. And as far as the elder child is concerned, he remains with me. It was not some temporary arrangement. He remains with me. Now, the dismissal of the family court proceedings, let me just find that, please.
I say respondent shall have supervised visitation with the minor children in Monroe County until further orders of this court.
Yes, ex parte order, my lord.
That's no
ex parte order at that point in time.
But you will have visitation there. That you have to go there rather than they coming here.
Yes, but at the time
And
the
what
court
is the
had
date
not
of
been.
the order is 26 June.
Yes, at the
One
time.
day before the departure.
Indeed. And at the time the court had not been informed that one of the children was here in India.
But in any case, today this order is there.
No, the proceedings have been closed, dismissed for want of jurisdiction. The same has been filed along with the reply, my lord. Page 41, please, my lord. The next page.
In a way, for the court to say you will have the supervised visitation.
Yes, my lord.
Is maybe at variance with what has been agreed to in the settlement. That in the eventuality you are unable to come, you will inform 6 months prior so that the children can travel. That gets nullified in a way.
Indeed. I may reiterate that I seek no punishment of the mother. I have no grouse as far as the mother is concerned. I only seek to have time with my children and for my children to spend time with each other.
But that's right. In any case, that you have to work out elsewhere. Today
I
we
am
are
trying,
in
my lord.
contempt.
Now you see, my lord, the proceedings in New York have been dismissed with the order at Annexure C,
Maybe.
page 41.
Maybe.
I have one child with me. He deserves.
Today you can argue only this. Those which have what are the terms agreed to are binding.
Yes.
For future.
Yes.
Insofar as the contempt is insofar as the 24 the summer holidays are concerned.
Yes.
This is the position.
Indeed, my lord. And now some time has flown by. Another summer holiday has come.
That you will work it out.
I have received an order from the family court in Bangalore asking the mother to keep the children present. Again, we are in non-compliance. I have reached out to learned counsel.
You will work it out.
I've made an offer of settlement, my lord, saying please send the children here for 3 weeks. That's all I ask. I will return the 3 children. I undertake, and my undertaking can be recorded before this honorable court. I don't wish to precipitate this at all. If the children come for 2 to 3 weeks, I'll be grateful. That's all I wish.
See, how can we add what has been agreed to between both of you?
Indeed, the proceedings have to go on in miscellaneous proceedings before the family court. I have
you have to work
initiated
out.
it.
Possibly you must think for varying the terms of settlement.
Indeed, my lord, but vacation comes only a few
This
weeks in a
contempt
year.
surely-
If this does not come, then
We should close this.
another year will go by.
Not here.
Not a contempt then.
I only seek that the
Yeah,
children
argue
don't
she
get
could not
alienated
have.
from each other. The oldest child is here. The 3 siblings are there. They don't speak to each other. They don't meet. It's been 2 years since the elder child met his own siblings, his own sister and brother. So all I ask, and there is no inconvenience to the other side. The tickets are already arranged by me. If they were to just comply this occasion, otherwise I will have to file another contempt petition now for violation of 2025 order of the family court.
See, we can't say now, foreseeing that she will violate it
No, I
and
agree.
initiate.
No, it is, in fact, I'd file an execution proceeding, and in the execution proceeding, an order is there to report compliance, send the children to India, report compliance. Again, there is
You
non-compliance.
and the one child who are here, you go there and meet them and come.
Going there and meeting them is,
As per your own.
I'm persona non grata over there. My father-in-law was critically ill. My son wanted to visit his grandfather. I was told, please
That
don't
is
come.
what the compromise petition says, isn't it? You shall visit there.
Indeed, but my lord, modification of it, as my lord is aware, is a
Unable to
trial.
travel alone, you take whoever you want to go with you.
Modification, as my lord is aware,
That
it will
is
require
not
trial.
yet. The remedy is
And that
not yet.
children may not
This
be.
contempt will close. Or you want to withdraw this?
May I request some indulgence, my lord? My stand is,
Your remedy is there.
my remedy is actually in the US, and in fact, attorneys in the US are now preparing for recognition, domestication, enforcement in the US.
This is not very good
Completely
concept.
avoidable in a scenario where they have made peace not once, but twice. And now a third round of litigation. So I'm seeking indulgence from this court. That's all. I've reached out to my learned friend. I've only asked for compliance if they come here. And the apprehension is that if they come, I
Call
will not
now
send the
between
children.
both of you.
Indeed. If it falls from my lord,
we will see legally what is there on record and then take.
if it falls from my lord perhaps, and my undertaking, the apprehension is that if the 3 children are sent, they will not be sent back. I'm telling your
What are
lordship
the
that
other
this
litigations you
apprehension,
have in India at present?
I have filed for modification, my lord, a miscellaneous
filed?
petition for modification.
Then
I
you
have
work
filed
out
it,
there.
but that's a trial, my lord. The children, summer holidays comes once in a year, trial will not be concluded before they turn 13, 14, 15.
What my lord has said, possibly you and the elder child must go there. You must be concerned meeting the children. That's it. And he, the elder child, meeting their siblings, his siblings.
School schedules in India and the US don't align, my lord.
Can't be. You should have gone earlier in the month of April itself. Who
There was a
prevented you?
family court order directing.
That is what your compromise says.
I understand. I understand.
Then
The
See,
family
we
court.
can't, we
with your-
can't have
can't change it.
solution for everything. Let's
I-
be clear.
The solutions are in
Okay,
the hands
thank
of the
you.
parties themselves.
Thank you.
If-
You want to withdraw this?
May I make one request? Madam?
Yes.
My proposition to the other side is if the
That's
children.
why you have to work it out. We say nothing.
Absolutely, absolutely. If my learned friend would just communicate this, that the apprehension that the children will not be sent back to America is completely unfounded. My undertaking to return them is placed before your lordships. And while your lordships are here to supervise my actions, perhaps there will be some confidence. If that can be done, I'll be happy to withdraw this and execution proceedings.
We will not say any word extra.
Yeah, you have argued, she has heard.
Indeed.
That's
Would
all.
my lord
It is
please
between
grant,
you and her.
would my lord please grant me the indulgence of letting this remain on board for a week or two so that I can at least speak to my learned counsel so that
We'll
we
work
can
it
make
out.
peace.
What is there, you'll work it out.
It's vacations are ongoing at the moment and they will
Your
end in
Lordship, with
August. If
respect to
something
the-
happens in July, I'll be happy to withdraw these proceedings.
With respect to the proposal which they have made, we have already conveyed, we do not have any problem with complainant visiting USA. We'll give full visitation to the complainant when he visits the USA as per the terms of the compromise, Your Lordship. This has already been relayed to my learned friend here, Your Lordship.
Kindly indulge me, if my lord would be so kind. Kindly keep this matter on board and allow me some time to speak to my
Request of
learned
counsel
counsel
for
on
the
the other side.
petitioner, re-notify next week.
Much obliged.
Whatever you want to work it
I will-
out, otherwise we are clear now.
I'll do my best.
Next.
Grateful.
15, sir. Serial number 11.
Going for the appellant.
Lord, IA number 1 I filed.
Yes,
IA
you
number
have to-
1 of 2025 filed, my recall the order dated 27/1/2025 for issuance of dispense of notice to respond number 5 to 10. And tagged with the appeal in appeal number 444 of 2024, arising out of the same order passed by learned single judge.
That application. Where is the application?
Dispensation notice. Recall the order.
You want that notice be dispensed with?
Please, my lord, from respondent 5 to 10. Those are the petitioner before the learned single judge.
Just say this, what do you say, Mr. Charati?
If they are the petitioners before the learned single judge, no, at least recent.
Oh, they were petitioners?
They were the petitioners before the learned single judge. That's what he says.
4 to 10, my lord.
So why are you seeking dispensing?
Because that month thou not interested to file an appeal against our learned single judge order.
They are the petitioner before that who has suffered the order from the Lord Single Judge. Only
Who suffered?
suffer, my lord. Only respond number 3 filed in one more appeal.
So why have you come now?
My lord, I'm challenged that, my lord, accusation is not proper.
What is not proper?
Proper is that, my lord, the possession has not been taken well in time. There are
So you are only preferring the appeal.
among the petition number 3, one appeal has been preferred and connected with 944 of 2024, which is also pending, my lord.
See, this is an application filed by the advocate for the appellants, Mr. Parshuram R. Atarakihal, seeking recall of order dated 27. Just 1 minute. Recall of dated 27, order dated 27/1/25. And to dispense with the service of notice on delay application as well as the main application to respondents 5 to 10. What is this 944?
It is one more writ appeal filed by the respondent number 3 in the petitioner 3 in the single judge order, arising out of the same land single judge order.
Against the same?
Please note.
Who has filed that appeal?
The R3, the respondent number 3 in the petition number 3. Amayama.
Which is this roster?
Illide.
44.
945.
Here only. For further tagging the present appeal with writ appeal 944/24. What is the date in 944?
That is not at given.
Huh?
That is not at given.
17/9.
17/9. Okay. Noting the prayers made in the application, comma, the notice on the notice on the appeal shall be confined to the respondents 1 to 4. The notice to respondent number 5 to 10 is dispensed with at the risk of the appellant. First, the Mr. Charati states that the writ appeal 944/24 also arises from the same impugned order.
I'm not aware.
Very well. Just take it that. Just the learner counsel for the appellant states.
Please.
That 944/24 also arises from the same impugned order filed by the petitioner number 3 in the writ petition Srimati Amayamma. Full stop. If that be so, comma, this appeal shall be listed on 18/9/2025. When we are informed that writ appeal 944/24 is listed. So we will have it on that day.
Please.
Then we will see.
Please.
17/9.
IA 1 of 25 is disposed of.
Serial number 12.
For the complainant in this matter, my lord.
17.
I believe the arguments on behalf of the complainant will be taken over by senior advocate Saidi Bek, my lord. He is logged in online.
Yes.
Serial number 12.
Is service effected? Yes. Surely. We can't hear you, Mr. Deepak. You are not audible.
Am I audible now, minutes?
Yes.
Please, Judge.
In the service
In
effective.
contempt petition 960 of 2024,
Yes.
notice was issued on the 2nd of April
Notice has
2025.
not been, notice has not been effected on 1 and 2.
Service has not been affected, Millets.
You just say that service notice to respondent number 1 and 2 is.
This is one more submission before that, before my notes passes an order. Kindly
Yes.
take a look at the order of 2nd of April just for a moment. There appears to be a slight discrepancy in the order, and I'll just make a submission in that regard. It says that respondent number 3, Mr. So-and-so, who is the chairman of the authority, is not a necessary party, when the fact of the matter is, statutorily speaking, he is the chairman of the authority, and he is the one who has actually convened the meetings, and he is the one who's issued the contemptuous letters. So for him not to be issued a notice and to not be deemed as a necessary party, if I may say so, it takes the sting out of the complete petition altogether. The
But
authority
you have to file an application, Mr. Deepak.
If I may say so with the deepest of respect, I'll move an application if my lords deems it fit. The only problem is, this is on the face of it. Let me just show the letter for a moment which has triggered this contempt petition, and then my lords would actually see what has happened in this.
But you
Kindly
may be
stand.
right. But you may be right. Today this order stands.
I understand. Can I just show
Right.
one order for? I'll just show one order for a moment. I'll leave it at that. I won't push the envelope beyond that. Just for a moment.
You know, we don't say
Kindly-
anything. If you want to file any application for recall, you may. We will consider it. It's up to you. But as long as this order stands, we can't do something which is at variance with that.
In fact, Millets, I was present virtually for this hearing, and to be candid, this was not part of the oral dictation when the order was actually passed.
So let's not go into that, Mr.
I'll leave it. I'll leave it to that, please. I'll leave it to that, please. I'll move an application.
So we are not. Are we to record your submission on this, or we just only say notice not affected on 1 and 2? Will you issue fresh notice?
Will I issue fresh notice with respect to respondents 1 and 2? But
Yes.
as far as the other issues concerned, kindly record my submission. That will be moving an application in this regard. Because I don't want this to be
on the previous order.
respondent number 3. Please, Millets, that you'll be moving an application to that effect. Kindly
So we
record my
will
submission.
just say that at the outset, Mr. Sai Deepak, the senior counsel appearing for the petitioner, would submit that the respondent number 3 is also a necessary party, as you say that he is the chairman or the.
He is the chairman of the authority.
He is the chairman of the authority.
And has issued the impugned letters in question.
And has issued the impugned letters in question. Full stop. Full stop. That apart, we find that. No, you want our finding on this?
My lords may say that an appropriate application may be moved in this regard.
Full stop. Having noted the submission as the order dated 2/4/25 is very clear, comma, we deem it appropriate, and the said order is very clear, and the said order stands unless it is reviewed or recalled, comma, as respondent number 1 and 2 are still unserved, let fresh notice be issued for service on respondent number 1 and 2 returnable on.
Please, that's good. My lords, consider giving a short date because it's a serious issue. Consider giving a short date.
You have to serve them. If you want, you can take hand summons also.
We'll do that, fellas. We'll get that done.
Issue notice, including hand summons. Returnable on. Just give it whatever is convenient. First week of August or so.
7/8.
Grateful, Millets. Deeply obliged.
We'll come back.
Much obliged.
We'll come back after.
that I'll have to challenge if need be. The
No, but this notification has been set aside.
set aside
by
as of
judicial
now.
order.
That came to
What
my
does the
knowledge.
notification say?
Notification had allowed only for that. The very particular point has been this thing that LPG go down is permitted, whereas LPG filling stations are not permitted. So therefore, they've set aside the notification. Your Lordship.
So that means filling
That
stations are
I do
permissible.
not have. Yes.
Then I don't think you should pursue this.
That's why, Your Lordship.
You want to withdraw this? Okay. After some submission, learner counsel for the petitioner.
And also, Your Lordship, one particular point was that particular residential area has to this day not been converted into commercial premises, Your Lordship.
That's irrelevant now, man.
Because of the zoning.
That we will see as and when something commercial comes there. He wishes to withdraw the writ petition. The same is dismissed as withdrawn. Just say that the report is objection overruled.
Serial number 23.
This is a matter arising out of commercial OS. I have filed an application for restoration. Your Lordship was pleased to pass an order on 4/3/2025 to comply with the office suggestions within 3 weeks. But due to,
How many objections are still sustaining?
and I don't think I have complained.
Oh, then you comply it first.
I'll comply it. That's what I just want to be restored and give me a chance to comply it.
Pending consideration of IA 25 of 21 or 25. The learner counsel for the appellant must comply with the office objections put in the commercial appeal. Re-notify.
15/9. 24 urgent. 25 urgent. 26. Shri Sitaram Rao. 26.
Yes, ma'am.
It was as such order that the respondent has given us served us a copy of the non-compliance which has been complied with.
They have complied.
Please, Manoj.
We have complied.
served a copy.
So what do you want?
Yes, Manoj. We can wind up the complaint.
You will withdraw.
Yes.
The learner counsel for the petitioner complainant states as the respondents have complied with the order of which non-compliance is alleged, she shall withdraw the contempt petition.
Yes, 27. Narayan.
I have filed a contempt, my lord, the order of the learned single judge.
27.
Order of the divisions of this honorable court has not been complied with. I have not been paid as the lordship may take para
This is over. This is over.
5 of the order, my lord.
According to the single judge order for the fixation of pay scale, it took 5.
What is this?
Para 5 of, no, if my learned friend's submission is that he has considered the application, the one portion of the order, he might have, the other portion of the order, lordship may kindly see.
Let them
That-
file it.
Oblige, man. Week's time I will file it.
Learner counsel for the respondent seeks and is allowed 2 weeks to file
Please.
reply affidavit.
Week's time, my lord. 2 weeks.
Let's go a copy.
30th July.
Now, 2 weeks will be, because I have not been paid salary, my retirement. 1 week time may be granted, my lord.
30th of July.
Pardon, man.
30th July.
Oblige.
28 and 29 urgent. 30. Shri Arjun Rao. 30. Your Lordship. One submission, Your Lordship. Serial number 28, Your Lordship. There's some urgency. We have been not informed, Your Lordship. There's a renewal of passport for a minor child, Your Lordship, which has been expired.
Yeah, short time now.
Your Lordship.
You appear for whom?
A complainant, Your Lordship.
See, this was sought on your behalf.
No, Your Lordship. Respondent have taken because they are petitioner appellants in writ appeal.
You are in contempt.
Yes, Your Lordship. There are 3 directions to give a consent for renewal of passport. Despite that, he has not given, Your Lordship.
Who is the counsel?
Sucheta.
It's the other side.
Sucheta Majumdar,
Can you
madam.
just call them?
Sure, sir.
Just call them.
Yes, Your Lordship. 30, serial number
Serial number
30.
30, I'm appearing for the appellant, my lord. Yeah, we've issued notice. They're yet to appear. Any short date?
Fresh notice be noticed to the respondent. Let fresh notice be issued to.
My lord, any date, my lord? There's some urgency.
6, 8,
Grateful, ma'am.
31, Shri Vasant Kumar. 31,
None for the petitioner. None for the petitioner, adjourned to.
Rectify some officer.
In the meantime, office objections be cleared.
Office objection to.
18, 8, 32, serial number 32, Shri Vas-
Weeks time, my lord.
Last date of hearing, my lord. They have
Lord,
taken, they are asking for 2 weeks, my lord. Your lordship has granted another.
In advanced
one
stage,
more
my
week,
lord, decision is awaited. The direction is to open the sealed cover and grant it.
You want?
2 weeks we will comply, my lord.
As a last opportunity,
There's no timeline set, my lord, but we have made
2
progress.
weeks
my
are
lord.
granted to file reply affidavit.
Grateful.
Sealed cover procedure.
29, 7, serial number 33, Shri Ravi Shankar.
For the accused respondent.
Yeah, for the complainant, because I seek 3 days accommodation. My client was not there in station
At the
regarding.
request of counsel for the petitioner, adjourned to.
20th August.
This is also.
Thirty-four, Shri Satish.
I'm appearing for complainant, my lord. Office objection is with regard to why the accused number 1 and 3 is made as a party. Lord, may kindly take annexure A, page 20, my lord.
What is the problem?
Since the direction is to the respondent number 2, accused number 2, my lord. Office objection is why the accused number 1 and 3. Lord, may kindly see the direction, my lord. At page 20,
Correct.
please, my lord.
For the accused number 1 and 3, there is no direction.
Please, my lord. But to implement the order, the government accused number 1 and the accountant general is necessary, my lord, to implement the order. I've stated in my pleadings, my lord.
Why you are bothering about that? It is a lookout of the accused number 2,
Please, my
isn't it? You
It is
go
true,
to
my lord.
accused number 1 and 3
But-
if necessary and do things.
But after that,
To implement the direction given to number 2.
they may say that there is no.
Number 1 and 3 are necessary.
How are you concerned with them? You are concerned with your own order to be implemented.
Please, my lord.
That's all.
But thereafter, they may say that we have not been made as a
They may
party.
say, they may not say. How are you concerned? They have to implement. Direction is to them.
Direction is to accused number 2.
Administration.
Please, my lord. The director municipal administration. Page number
Yes, what
20.
is your case?
My lord, notice, I will take notice, my lord.
Fresh
Notice
matter,
a
my
Fresh matter, my lord.
Notice. Learned AG accept notice for all the respondents. reply affidavit be filed within 5 weeks.
My request for a date, my lord.
19.
Grateful.
35.
Just show this.
35, my lord, I represent the complainant. The direction, my lords, was to enroll the applicants and similarly situated poor persons from becoming members of the association.
Yeah.
That has not been done.
We are issuing notice
Please.
returnable on give a date.
39. Seal number 36.
My lord, in this case, I am for the petitioner, my lord.
Yes, so file the petition.
Date.
My lord, I appear for the respondent number 9 in this matter, 36. I'll file, I think.
Your lordship's direction, I have served the copy on R number 5, unequal planning authority. My lord friend appears.
Respond
for
number
all
5, madam. I appear for respondent number 9. Want to file some objections to this matter.
Yes. What are the instructions, ma'am?
My lord, the notice that has been issued, my lord, that assistant executive engineer has since retired. My lord, on 30th June 2024, on my instructions, he has taken charge as a chief data. My lord, he needs some time to look into the file and make it, to give instructions.
What is your this thing?
My lord, my prayer before your lordship is that this R3 has given approval for putting up construction over a canal, and under the guise of getting approval from A3, R3 to put up a canal, he has put up bridge. 9th respondent has put up a bridge over Henagara Lake. That is my case, my lord. Under the guise of getting that order. In fact, nobody can give such a direction as per your lordship's. That too in a buffer zone.
It's not the only officer who takes a decision. The file moves, the views are put.
Yes, my lord.
And then the approval is given. Why the one executive engineer who has retired, the whole thing must get this thing? There are other officers who are looking into it. And where does the file go for approval, final approval? Executive engineer, superintending engineer, maybe the chief engineer. Who are the people who have given this approval?
The construction is not on a lake, my lord. The construction is not on a lake. As a matter of fact, the plan that they produce is actually a wrong plan and a sketch.
Yes, you know, what is the officer saying? Will he give instructions to you?
My lord, he doesn't have the records to give instructions. So that is the reason why I'm seeking for 2 weeks. He's present this moment.
No, not 2 weeks, ma'am. Ask him to get instructions. We'll give you a week or 10 days. Just say that
Lord, in the meantime, may I request your lordship to kindly direct AEE to produce that annexure E, my lord, which I am unable to produce because.
1 minute, you have heard what the AGA is saying.
Please, my lord.
Have you heard it? Have you
Yes,
heard the AGA?
Records are not available.
The annexure would be part of that. Just say this at the request of so in terms of the last order, comma, what is the good name of the officer?
My lord, Mr. Vasu.
That's a full name, ma'am. Mr. Vasu P, Assistant Executive Engineer. He is present before the court to stop on instructions from the officer, comma, the learned AGA seeks a 10 days time to take instructions.
In the meantime, may I request your lordship to kindly direct R9 to stop further construction for the.
See, we will,
No.
if ultimately if it is found, it is illegal, we'll ask them to demolish it.
Please, my lord.
That's all.
And I think R9 is represented today.
Yeah, Mr. Chinnappa, you appear for whom?
Yes, my lord. For our respondent number 9,
What is your stand?
our stand, my lord, is it is not in the lake at all. As a matter of fact, there is a small water flowing there, but it's not part of the lake. There is a complete survey that is conducted by all of them. My learned friend has produced a document which is not the complete document.
Even if that Google map is look into it.
Take instruction, madam. You
Not
must
Google map. The
also
survey
file-
records is there.
You will file an affidavit also to take instructions and file an affidavit. We want to know what is the factual situation.
Insofar as R5 is concerned, my lord, my learned friend appears. Mr. Yogesh
Are
Naik
the
is
others
appearing.
appearing?
I'm appearing, my lord, respondent number 5 itself.
You appear for so and so appears for
R5.
five.
R5.
Notice
I've served a
to
copy on him.
note and Mr. Chinnappa, who is briefing you?
I think he should be there, my lord, in court.
So and so appear for R5 and R9. Let notice be issued to R7.
Notice is already gone, my lord. It's awaited.
Just say, then do one thing. Just
Please.
say this, notice report on R7 shall be submitted to the court on the next date of hearing.
(22-7),
Obliged, my lord.
rule number 37.
I am for the petitioner, my lord.
I appear for respondent number 1, my lords. That's in this matter, my lords, the prayer which has been sought for is at page number 18, my lords, seeking for a mandamus. My lords, it's essentially a dispute between a developer and the owners of the association. My lords, mainly, my lords, they had made a submission. Respondent number 2 had made a submission that we have already handed over the STP and other operation to the petitioner. And my lords, on the last date, they even filed their affidavit to that extent on 15/4/2025.
My lord, the STP is not handed over to the association. Association have not taken over the maintenance of the STP because the STP itself has got inherent problems. So this KSPB has just issued CFE and then COO without looking into all these things. And then when we made the complaint and they came and then assessed it and they found that, okay, there are problems in that. And then they have not rectified it. When it was supposed to be for 47 KLD, they have repaired it for 30 KLD. And when they spent about 6.5 lakhs for installation of STP, they have spent 5.5 lakhs for rectification. That means to say you should be knowing that, like, how much money they have put in for the installation and then for the repair itself is a big thing. And then after that, they have not renewed it after 30/9/2023. After that, they have issued letter under notice under 33(1). Earlier, they have issued it to these builder also. They have not taken care of that. That is why I have from 2022 I've been this petition is pending. What I am asking is like they will have to monitor the modification whatever they have done. See, there are guidelines, my lord. All those guidelines are not followed. When there is a problem, inherent problem in this, and then it was not functioning properly. So that is why I asked for, before taking over, I asked for a third-party inspection at least. Otherwise, let them make a report of that and then submit it. And then I don't want to carry the baggage what is left by these builders on me, because tomorrow they will come and then put a lot of levy on me, the penalty on me. I don't want that, my lord. That is why this petition was filed. That is why I asked for the direction from this honorable court, my lord.
I beg to appear for the second respondents, my lords, in this matter. This rightly pointed out by my learned friend that this is regarding handover of the STP, but the fact remains that this association, which is the petitioner herein, has taken over the maintenance of the project way back in the year 2021. And this project is one which is registered with the real estate regulatory authority. And that being said, they ought to have taken over the handover of the entire project. However, my lords,
Annexure N can be referred, my lord. Page number 97.
The only thing is how a writ is maintainable, my lords, is something which
No, but
which is something
because
which is not explained.
they issue
Writ is not
CFO, they
maintainable,
issue
my lords.
COO. They should be careful enough to when they were issuing it. They just can't close their eyes and then issue all these licenses and then put us into trouble, my lord. So we are just an apartment association, we're not the builders. Tomorrow, like all those things will come on me. I'll have to pay for all that.
My lords, that is on account of their own inability to take over the maintenance of the entire project. And in fact, the
It
CFO,
is
which
not
my
right. How
learned,
can I take over?
Have you filed your affidavit?
yes, my lords,
They have
we have
filed
the affidavit
As far as
also.
I am concerned, my lords, we have nothing
You
to
appear
say.
for whom?
My lords, I appear for respondent number 1, my lords, Karnataka State Pollution
Have
Control Board.
respondent number 2 filed the affidavit?
Yes, my lords, we have filed the affidavit.
Where is the affidavit?
In fact, my lords, they had made a submission that it's been taken over, my lords, but the bench insisted that let them come on record to say that the petitioner association is taken over, my lords. That's why it got adjourned.
In fact, my lords, one more submission is that there are no guidelines, and in an order in the same project which is now passed by the regulatory authority says that the association ought to have taken over the STP also. And there is no provision of law which allows them to take maintenance of a project in exclusion of the STP. So let them make submissions to that effect. They're unnecessarily trying to shift their burden onto the KSPCB and to the promoter by filing this writ petition. In fact, there is no relief that is sought as against the second respondent.
And even on the petition also, even on the affidavit also, they declare wrong. They say 50 KLD. When I see that they've said 30 KLD in their repairs. They don't know what they are talking about. When the wastewater generation is
Hello,
40
kindly.
KLD and then it is 38 KLD is what is generated. What is collected is 47 KLD. They are stating here that 50 KLD, but in the repairs what they are saying is only 30 KLD. So when that is the case, then tomorrow they should not come back to me with all these things. See, we are ready to take over the STP, provided that there is a proper audit to that payload. That is all. See, we don't want to take over something defective one and then tomorrow get into trouble, my lord.
It is between you and the developer.
My lord, that is why
the builder,
that is right, my lord. But they
to make an audit of it and take over whatever that is there and then deal with the
my lord, the
KSPCB.
KSPCB should approve that. See, now that
That is none of their.
no,
We don't know about what is your contract with the builder.
No, contract.
Builder may be having 100 KLD or 10 KLD. It is between you and the builder.
My lord, they have given the CFE and then CFE is given for what? CFE is given for 47 KLD. See what?
That. Should we examine that?
No, my lord, I have examined that. That is what I am submitting.
Examine that. As per that.
But how can I take over the defective one tomorrow if it should not be on me, on my account, my lord?
How come a writ petition is maintained?
My lord, it is for the KSBCB to monitor this, my lord. This
your private property, how they should work.
My lord,
if there is violation, they will slap a fine.
My lord,
Yeah,
violation is that. That is what I'm saying.
In fact, the consent which we have issued, my lords, has lapsed. If that so be the case, they should have come before before us, my lords, made an application saying
they will examine it.
We will examine it. Now, my lords, today they are running an STP, whether it's defunct or defective, whatever it may be, without a consent.
My lord, he is not submitting it rightly because I have given the complaint to him. What did he do all those days? So I have given the complaint. We'll examine that, my lord. We'll examine it. I have given the complaint to him. This is on. They have come and then given the show cause notice on the 6th April 2022. See, that time, like it was under force. That CFU was under force. See, COO was under force. So they have not done anything. They were like they are siding with these builders. Tomorrow they will put all that levy on me, all that penalty on me. They should make some audit and then say that, and then we will take over.
What kind of an audit?
Saying that okay, this is right or wrong, my lord. As per their guidelines, if it is right, if we let them say it is right, and then we will take the photographs and then we will accept it. If it is wrong, let them say that.
Who appears for pollution control board?
That's,
So you can certify this is as per the regulations?
it's not as
STP?
per the regulation. We've already issued a notice.
Oh,
to
you have
that effect.
already issued a notice?
Yes, yes. In
Then
fact, it's
what
annexed
is
to
your, what
AG.
is your prayer then?
It's annexed
It's
to
not
AG.
as per the, this one means let them give a letter to saying that, okay, it's not as per their guidelines, and these are the defects, and then whatever is the liability comes, let the R2 will pay favor. That we will take it up separately, my lord.
Who appears for R2? Yes, ma'am, tell
I
us, what do
appear
you
for
say?
the second respondent, my lords. My submission is this, that till 2021, that is till the learned friend, the petitioner could have taken over the association and the maintenance. I was liable to maintain the STP. I have done that. In fact, I've done it till February of 2025. And the CFO, which my learned friend points out, has expired in 2023. Any audit thereafter, my lords, is going to be adverse to my interest,
But
because
tell us one thing, if the audit is done today and it is found that even before 2021, the STP was not meeting the regulations of the pollution control board, then are you not liable?
Yes, my lords, but that has to be before 2021.
Very well. When the project was, or when the flats were taken over, or the association was formed.
Yes, yes.
What do you say?
Yes, my lord. Even
Is it your case even before 21 also?
Yes, yes,
Okay,
my lord.
very well. Then if that be so, then the liability, whosoever, yes, you will do the audit. You have done the audit, no? You have done the audit. You have done
We have conducted inspection.
That's right.
And we have given a letter on 28th November 2024. Showing
Now
the
tell us
shortcomings.
one thing, these deficiencies,
Yes, my lords.
Relate back to prior to 2021?
I would say that, my lords, it would be continuing, my lords.
Continuing from which date? 18
My lords,
or
that would be difficult in terms of.
1 minute.
No,
If
that
you
is
have certain regulations pre-21, those STP must meet those regulations.
Yes, my lords, at page
Right?
76.
If those regulations have been met, they may not have any liability.
Please, my lords.
If anything has come thereafter, further regulations have come to update the STPs, possibly their liability to bring it in conformity with your regulations.
Yes.
My lord, like we will take over only after this, my lord. See, we have not taken over that. From this today onwards, it will be on us.
What is the date when you have formed the association?
So, my lord, we have given the letter saying that we have taken over all other common amenities except STP.
From
because
which date?
That is
That is in July of 2021, my lords.
That is 28 February 2022. We have issued a demand letter to them saying that, okay, STP is not working properly, rectify it.
When did you took over as an association?
Association we have formed in 2021, my lord.
July, my lords.
21, yes.
Given July?
Yes.
If the STP is in terms of the guidelines and the regulations of the pollution control board prior to 21, and the STP confirms those regulations, then they may not have any liability. But if the STP does not conform with the regulations issued by them, even prior to 2021, the liability would be theirs.
They have maintained it till today, my lord. They are maintaining it till today.
We are not.
On what basis they are maintaining it?
Because we have not taken over that, my lord, because it was defective. That is why we have not taken over that.
Right. So defective
This
means
is
you are
an
right.
unfair submission, my lords. I'm
1
sorry.
minute,
that
ma'am.
I'm interrupting.
Just 1 minute. It's just think logically. You taken over association in 21. You form the association.
Form the association in 20. Yes, my lord.
Thereafter, you are looking after the affairs of the
Other common. Yes,
facilities. Now you have an issue with our ATP is not working properly. It doesn't commensurate the guidelines issued by them.
Yes, my lord.
If it is so, then it would be tested from the regulations issued which were invoked before 21.
Yes, my lord.
If it is so, the liability would be theirs.
But they have given the show cause notice on 6th April 22 only, my lord, saying that, see, it is on our complaint they have given the notice, not on them.
They have to regulate it. They say we have inspected today. This doesn't meet the regulations.
Yes, my lord.
But what we are saying is the cutoff year is 2021.
No, my lord, because we are not taken over the, see, it is on our complaint, my lord. They have
What
issued.
is not taken over? How is it relevant?
My lord, I just, see, they have issued the show cause notice based on,
We'll ask them to see the STP in terms of the regulations in July 21. They will see that STP from that perspective. If it is not meeting the regulations of July 21 also, they are liable. We hope we are clear.
Yes, my lords, may make one.
You can carry out this exercise.
It may not be possible, my
Why?
lords. I'll explain to that.
How much is the liability coming on them?
That's, as of now, we have not imposed anything, my lords, on them.
But you will impose, what would be that?
It's like this, my lords. The cost which we are going to impose upon them is not for the purpose of maintenance of STP. It is in case there's pollution which is found. No, my lords, as of now, it's not been done.
You are right, but the liability would come on them. He says, I am not liable, they were liable, they were to install STP in accordance with your regulations.
Please, my lords, that's why, my lords, may make one, I won't take 30 seconds, my lords. That's what we do is that, my lords, we first issue something called a consent for establishment, CTE, my lords, which is at page number 60. That is dated 4th April 2018. Now, my lords, after inspection, we have given them something called CFO, consent for operation, which, my lords, is dated 1/8/2019. Now, my lords, after 1 year, they've started the operation. Now, my lords, maximum, my lords, we may have the
Suppose
record.
if it is found that when you gave that approval concession or operation consent, the STP was not actually meeting the.
It could not be so, my lords. Only if it meets the conditions in
Then
CFE,
only you give.
then only we give CFO. It's for establishment and then for operation. My lords, subsequent to which, unless until we have done an inspection, my lords, we would not have records to go back to 2021. That's the date they are commensurating, my lords. That is July, August 2021, my lords. It was a COVID time. That's for us to go and do some inspection also. It would not have been possible for KSPCB. My lords, to go back to that date, it might be a bit difficult, my lords.
You may not. Why not?
That's because we
What
may
is
not
this?
have the records, my lords.
You're not understanding. You have the regulations. A, B, C, D need to be followed.
yes, my lord.
Whether the STP was commensurating the A, B, C, D.
Yes. Even they should.
have so.
Yes, ma'am.
We have an office memorandum, my lords, which they have enclosed at page number 98. Now, my lords, it says that ABCD is what my lords have pointed out. My lords, should be there. Now, as of that day, my lords, when we were giving CFO, that would have been there. Now, my lords, subsequently, what would have happened is that, my lords, some nozzles would have gone away. The flow meter would have been affected. As what they're saying, 30 KLD, there's a influx of another 17 more KLD. Now, my lords, there might be pressure. It is like any other construction, my lords. An STP is like any other construction. My only humble request, my lords, going back to that date, I'm not saying it's impossible, my lords, we'll have to go check our records. But in any event, my lords, if they have a grievance with regard to the builder, my lords, they would definitely have a defect curable time period, my lords, under the Act, under which they've been handed over the properties and apartments. They should go and work it out there, my lords, not bring us in between.
No, my lord, that has been done. KSPCB, we have given the complaint because they are supposed to issue the licenses. When they have issued licenses, they are liable. See, now, my lord, what is happening? Oh no, what is happening? Activated sludge process, it should be above for 500 KLD, my lord. This is only 50 KLD. How did they allow this? And then it is constructed in the underground, which should have been above the ground. Let them check that even on 21 also, my lord.
You will do it. We say nothing. This is not for us to look into everything.
Please, my lords.
These are all disputed facts. Nothing, everything. You will, and you are the regulator.
Yes, my lord.
We'll go check up
Yes.
whether that has been properly installed or not. Then put it to them, if any.
That's as of 2022, the STP was not even functional according to our inspection.
Was not functional?
No, it is not.
Who was responsible?
That's the association.
Why?
They just 2021, they themselves say we have taken over.
So we are not taken over. Where did we say?
That
We
2020
never said that. In the affidavit,
Even
they say-
2022, they
Read
make
the
a
affidavit.
mention. They make a mention of 2022.
Yes, one.
See, 5,33,990. When was it spent? It was spent on 25/3/2022 by the
We don't know,
builder.
we don't know about it.
No, you see this. No,
That
this
we
is there
would
in the
not know
affidavit.
about it.
It is there in the affidavit. I did not spend this money.
When did you took over the other facilities?
That was in 21, my lord, approximately. We started giving the notices. (2021), my lord, I can.
What is the date, year, month?
16th, maybe 16th August or 16th August 2021, something like that, around that time. My
The
lord.
present petition
That is
has been
Annexure J, my
filed
lord, lab report we got.
by the
Copy of the
petitioner
minutes of the-
association with the following prayers. In effect, the prayer sought is primarily in the background that the respondent number 2, who was the builder promoter of the apartment complex Krishna Gardenia, had put up an STP in the apartment complex. Full stop. Thereafter, full stop. On the flats being handed over to the members of the petitioner association, and the association having been formed, having been formed, the association had taken over the common facilities in the complex. So the case of the petitioner as contended by the counsel by its counsel is that the petitioner had not taken over the STP, as it is the case of the petitioner that the STP was not working properly, resulting in lot of pollution being created, generating a lot of pollution, including bad smell, as the water is filled with untreated solid, generating the worms and mosquitoes. Full stop. According to the learned counsel for the petitioner, it is the responsibility of the respondent number 1 to monitor the STP, to ensure monitoring of the STP by the respondent number 2 promoter builder. In other words, the petitioner association has nothing to do with the working of the STP. Full stop. The respondent number counsel for the respondent number 2 would submit that the association the flats having been handed over and the association having been formed, and thereby the complex has been handed over to the petitioner. It is the responsibility of the petitioner association, in collaboration with the individual residents of the apartment complex, to maintain the STP. Any liability of any nature cannot be fastened on the respondent number 2. Full stop. On the other hand, the counsel for the respondent number 1 states that the respondent number 1 board being the regulator, ensuring the regulator in respect of pollution, its obligation is to ensure that the water is not polluted. Water and air. Water is not polluted, and the standards as laid down by the respondent number 1 in running the STP are maintained. Full stop. We have heard, full stop. The issue which primarily arises is, full stop. He also states, just say that, he also states upon inspection, it has been found that the STP is not working properly.
And we issued,
generating pollution, water pollution.
issued notice of proposed direction under section 33A of the Water Act.
And various communications, including a notice under section 33A of the
Water Act.
Water Act has been issued to the association. Full stop. Association. And any liability determined by the respondent number 1 has to be honored. Full stop. An issue has arisen whether any liability that may come because of the pollution generated by the STP have to be fastened upon on the association or the respondent number 2 builder who had actually installed the STP. So there is no dispute to the fact that the association having been formed had taken over, having been formed in the year 2021, had taken over the common facilities in the complex. So the submission of the learned counsel for the petitioner is that the association has not taken over the possession of the STP, knowing well that the STP is not functioning properly. Full stop. Functioning properly. Full stop. So the issue is in narrow compass. If the STP was malfunctioning from the before which month you said, July or August?
Miller?
Which month you said?
They
before July 21, when the association was formed and taken over the common facilities, then we are of the view then the liability to maintain the STP, the obligation to maintain the STP was on the respondent number 2. If it is otherwise, that is the STP started malfunctioning only after the association has taken over.
My lord, they have submitted the affidavit saying that okay, they have did the repair. In this affidavit, it says that 25/3/2022.
What?
They have rectified. They have made the repairs to the.
It is the onus on the builder to rectify it. That's why I mentioned that the defect curing liability is on the respondent number 2. Insofar as the STP is concerned, until they start taking over.
Yes.
Now, that's today. I'm sorry, my lords, we are interrupting the dictation. That's the notice which my lords have dictated that we have issued. We have issued to both the petitioner as well as the respondent number 2. It would be a joint liability. Now, that's now going by that, my lords.
He cured only in 22.
They have submitted, my lords, saying that there were some defects which we paid and we repaired the STP.
Yes.
So you said 2022 also there was a
That's what they have said, my lords. The
2022,
respondent
they have
number 2
done
on
the-
their affidavit, they have stated so.
My lord, 2022, they have done the repairs, and then 2023, that is on 30th September 2023, that license expired. After that, it is not renewed, my lord.
License for?
License for
Consent for
COO.
operation to run the STP, my lords, is over back in the year September 2023 itself.
23.
Now, my lords, today, they are saying that, my lords, it's your responsibility, and they are saying we've handed it over. Now, my lords,
No, my lord, even the RERA has given last week order saying that, okay, take the handover of the STP. We are ready to take over the handover of the STP, provided they only inspect and then audit, say that, okay, you take over from tomorrow, today, we are ready to take
they
over.
should have done that before the authorities, my lords. That would have been ideal before the authorities, my lords. Now, my lords.
So then when do one thing, I think. These are all disputed questions. You go to the civil court. Go to a civil court. We will not determine all this. Neither they will determine. You will work it out. These are all evidence we to be looked into. From 21, 22, their liability, 22 after 23, your liability.
My lords, only one submission, my lords, from respond number 2.
Documented, my lord, everything is
Already
We
taken.
don't know what kind of an evidence is that.
And today, my lords, admittedly, they're without consent.
Without, you will go there. Go to civil court. Not get into this. Okay, what did we say? In fact, during the course of submission, our attention has been drawn to which is this where this 22 says.
It's this in the affidavit submitted by the R2, my lord.
Our attention has been drawn to the affidavit submitted by the respondent number 2.
Paragraph number 4, my lord.
You have copy? Name copy code pidi. Copy kodi. Ho sake.
Just give a copy.
This is the copy.
Has stated in the has in paragraph 4 stated as in the so it transpires that even in the month of March 22, the respondent number 2 promoter had carried out certain modifications to STB. Suffice to state, no, you have not determined the liability, no?
No, we have not, my lords. We are yet to do that, my lords. That, my lords, would be on the principle of polluter pays.
See, you should do your work. It is between them, they will work it out.
Yes.
Who will pay? If that be so, comma, the further issue which arises is if in the eventuality respondent number one imposes a penalty, public liability on the
Petitioner.
on the residential complex, who shall be liable to pay the same? Given the facts noted from the record, this court is of the view these are all disputed questions which need to be agitated before a civil court and not before a writ court. Appropriate shall be that the petitioner shall in the eventuality the petitioner association shall be at liberty to seek appropriate remedy for the prayers as made by the petitioner association in this writ petition. With the aforesaid observation, the petition is closed.
We'll have to apply for the COO now freshly. So
see,
we need the liberty to apply for the.
No, they are always
who is
set
stopping you? Today, your STP is not working. That's right. We don't know. So you better do that. We don't. Otherwise, there would be a further liability, further issue. They should pay or you should pay. Next.
Great for you.
This case, my lord, I represent the defendant, respondent, my lord. So may I seek a short pass over, my lord?
I'm, as far as IA number 1 is, my lord,
May I kindly pass over the matter?
I am withdrawing the IA number 1 for adjournment.
Passover is not difficult now. Which number you are IA 1 of 24?
25.
The petitioner who appears, the appellant who appears in person states he shall withdraw IA 1 of 25 for adjournment.
For adjournment, I am withdrawing that one.
Okay.
And as far as IA number 2 is concerned, my lord, it is only regarding 63 days delay that may kindly be condoned.
I'll be filing my objections, my lord.
No, how much then it is? I have filed this
1 minute.
very long.
Can be the serious objection on this.
My lord, there are multiple litigations have been gone, my lord. So in that, my lord, there is one more direction, my lord. He has to pay the cost.
Just file a reply.
Please.
Reply to IA 2 of 23 be filed within how much time?
2 weeks may be granted.
Huh?
2 weeks may be granted.
No, man, this may kindly be posted on 3/9. I will not.
See, this matter is pending from 23. You now seeking a reply, time to file reply?
Any short accommodation, my lord.
Or short
No,
accommodation?
no,
We'll allow
my-
this.
my-
What is there,
Please,
63
madam.
days?
Please.
Is an application seeking.
My humble
1
submission.
minute, please. Condonation of delay of 63 days in filing the above appeal for the reasons stated, Yeshwas. Stated in the affidavit in support of the application, comma, the 63 days delay in filing the appeal is condoned. The application is disposed of. Full stop. Though a passover has been sought by learned counsel appearing for,
Respondent, my lord.
which respondent?
Respondent number 1, my lord.
Respondent number
And
1.
as far as IA number 4 is concerned, my lord,
Hmm.
IA number 4 is already, I have requested to connect this case in the writ appeal 1282, wherein
It's
final.
connected. It's connected.
It's connected.
It is connected. Hence, there is no IA, it has to be withdrawn. Already it has connected.
Which IA said?
IA number 4 of 2000,
1 of 24. Is there any?
serial number 5.
Yes, there is.
Full stop. In view of the order passed.
In this case to 38.1. It's IA 1 of 24.
We need that order of connecting. We need that order of connecting. In view of order dated where is along with?
Appeals.
No, it is not right. It is
Appeals shall be listed.
there is no joining together.
Already we have listed, sir.
No. In view of order dated 19/12/24. Comma. The IA 1 of 24 is disposed of. Though a passover is sought on behalf of the counsel for the respondent number 1, given the position of the board, it's not possible to pass over the matter adjourned to.
It may kindly be posted on 3/9 for final hearing.
Written submissions be filed within 5 weeks, 6 weeks.
Please.
3/9.
Just 1 minute. Allowed. Re-notify. Yes, what do you say?
3/9, it may kindly be posted on
3rd of September.
3rd of September.
and my stay application is there.
We look into it. Next.
Please, ma'am. Okay.
39.
Petition of your lord recollect regarding the Saraki lake bed upper zone construction of a multi-story building, my lord. Is last hearing date, your lordship directed the fifth respondent corporation BBMP to file the objection and wakalat, my lord. Not complied.
May
For the respondent number 4 and 5 in this case, my lords. My lords, on the last date, we had to file wakalat for R5, my lords, but due to some unforeseen circumstances, we could not acquire the authorized person's signature. Hence, we'll be receiving the wakalat for R5 this week, my lords. Hence, I'll file it in this week, my lords. My submission may be kindly taken on record, my lords.
My lords may kindly appreciate.
BBMP, my lord.
There is an interim order operating against me, wherein my apartment building has been stalled because of the interim order at the instance of the petitioner. Now, my lord, this may be kindly appreciated that the petition has been filed without any proper verification. In fact, the allegation of the petitioner is 100-meter buffer zone is to be left from the tank, and that has been not done, and therefore there is a grievance. My lord would get it at page number 94. This is the grievance. Now, last time I brought to the notice of this honorable court that the zonal regulations of Master Plan 2015 says from the buffer zone for the water body is only 30 meters from the edge of the water body. That is the requirement of law under revised Master Plan regulation number 4.123 that I have made a submission on the last day. Now, my lord may kindly appreciate when the words used in the master plan is in case of water bodies, 30 meters buffer of no development zone is to be maintained around the lake. This is what the requirement of law is. Now, so far as my plan is concerned, the plan is before my lord, wherein it is provided that the 30 meter has been identified in the plan, the construction plan which has been sanctioned. Now, when that is the situation on, and I had also produced the CDP, which shows that in between my property and the lake, there was a road which was in existence even as per the village map which is on record, my lord. The village map of 1940 is also before my lords, which shows there is a road in between these two properties, and the property photograph are also produced before my lord, which shows there is a road, there is a wide road in between my property and the tank. And therefore, when the buffer is taken, it is from the water body. The water body is also properly identified, fenced from that edge of the water body. 30 meters buffer has been left. Even in my property, there is one small portion which is a buffer zone. That is also identified in my plan, construction plan. There is no illegal, but there is a interim order which is really troubling me because of the BBMP is not before my lord.
My lord, the thing, my
lord, half-heartedly, my lord may kindly peruse, even without knowing the name of the person who is being constructed, the name is the respondent's number 13 is shown as one with the name which is shown is not even in existence. They have mentioned the name as Messrs. Mahavir Developers, Jagruti Colony, which is totally incorrect. Then promptly they issue notice to me by saying that there is an interim order against you. They know my name, my corporate name. That I have brought it out in my statement of objections. This is the fraud being committed by the petitioner in this matter. Without verification, no preparation, the affidavit has been filed that I have verified all the documents and there is an illegality, and the interim order has been obtained.
Your lordship may
now, the workers, the labor is staying there without any work. Materials are lying. And after, though there was no interim order that was passed at the first instance, he makes a false submission that I am awarding the notice, and he obtains the interim order at the hands of this honorable court subsequently. Order sheet speaks.
On which day?
The order sheet may.
When was the interim order?
Interim order was passed.
2 years back, my dated.
That is on. My lord would get it.
My lord on
5/12/2003.
23.
This is the interim order passed.
And he quotes some name which is non-existent, fictitious name as respond number 13.
Has he been served?
No, he issues a notice to me to my correct address and name saying that there is an intimate against to stop.
To appear for whom?
Respond number 13. They show it as Messrs. Mahavir Developers. But my correct name is Reddy Structures Private Limited.
My lord, regarding that aspect, my lord.
It shows.
Kindly see the.
There is no preparation.
Kindly see the annexure R5 filed by the respondent, my lord. R5 filed by the.
Yeah, we will hear it. I think this would take time.
R5, my lord. R5 is the statement of objection. In R5, he states that kindly see the R5, my lord.
1 minute, counsel for the parties to file their written submissions.
Short at my lord.
Corporation director, they have the culprit. They have given the license, my lord.
No, it's very short point. What is the
within the buffer zone?
Who appears for R5?
R4 Prashant. Last time he was last directed to take notice and he admitted to file the statement. Last hearing date.
My lords, I appear in behalf of SH Prashant, my lords, for R5, R4 and 5.
They are not complied the directions. They are avoiding. Your lordship.
No, point is very short. In fact.
1 minute, please. Have you filed your counter affidavit?
No, my lords, we are yet to file it, my lords, because first we have to file wakalat for R5, which was not acquired by the authorized persons. Hence, we are seeking 2 weeks time, my lords. In that 2 weeks time, I will comply with the directions of this honorable court.
The respondent number 5.
In the meantime, my lord, one submission, my lords. I may permitted to go out with the construction activity. If I will not claim equities if tomorrow I am.
BBMP has to file, na?
File. BBMP has to file. They have given the permission to construction plan.
Appears for Karnataka Tank Conservation Development Authority.
The state will represent.
Yes, my lords. For R4 and 5, I appear, my lords. For R4, we have filed wakalat.
Now, who is the regulator?
My lords?
BBMP.
It is vested with the BBMP now.
BBMP. Now
the operation of law.
Lake also developed by the BBMP, my lord. BBMP is the.
You say ma'am, have you filed your counter? The respondents. What is this Karnataka stand conservation? They will. The respondent number 5 shall file its counter affidavit.
My lord,
may
submission, my lord. I have filed an
weeks.
application for additional evidence, my lord. Recently in 2024 December, corporation along with the ADLR and also Lokayukta inspected and surveyed and filed the survey sketch. That I have produced, my lord. That to taken on record.
Your written submissions.
In 2 weeks.
One make submission.
For that.
May be permitted to go out with the construction. And I will not claim equities, and tomorrow if it is in the buffer zone, I will unconditionally demolish it.
Even corporation also party to 24 plan, my lord.
2 weeks for rejoinder. Just give it immediately after 4 weeks.
My lord, in this month, my lord.
Your submission, you mentioned that. Without seeking equities.
That's what, in fact, my submission by break, and if I am permitted, I'll file an affidavit also to that effect, my lord.
You filed it. You filed
I'll wait.
Next.
I'll wait.
This month, my lord,
Urgent.
little bit difficulty.
Next.
40 urgent, 41, 41.
Commercial appeal against an order where the suit was dismissed for non-compliance with section 80. The suit was rejected for non-compliance with section 80. It's their admitted case that there is no interlocutory prayer. There is no urgent prayer. Registrar of Companies was made defendant number 2.
Still unserved. What is deletion of respondent number 2?
Respondent number 2 is Registrar of Companies.
It's an
You
employee of
want
the central
deletion?
government. It's an employee of the central government. We made an application under section 151 seeking dispensation of notice to him. When that application was pending, we made an application to delete respondent number 2 from the proceedings on the ground that he is seeking no relief against him. In addition to that, one more memo application is also filed striking respondent number 2 from the proceedings. When those applications are pending, the commercial court considered the IA number 151, since it is not compliant, therefore they dismissed the suit. Why they have not considered my application for deletion of respondent number 2 and I made an application under order 10-2 to strike it up. It was also not considered.
It's the same, right?
But he saw deletion of the 80, it becomes relevant for whom?
Lord, my respectful, I follow what falls from your lordships, but my
I
lord,
decided that application.
my respectful submission is there is umpteen case law saying if 80 application is filed first, that is the application which must be heard first because the suit itself is irregular. Therefore, no other
Tell us
application.
one thing.
Please,
80 application filed.
please,
He realizes, oh, he has made unnecessarily him a party.
please,
Is it deleted?
please.
What follows? You should
Either
delete.
81
Your,
applies,
your
not
application
82
would
also.
become infructuous.
Lords.
80 application, whatever the
He has filed
application,
80 application. The
Very good.
plaintiff files
or exemption.
for exemption. So,
Oh, so once he say deletion, even
Please.
80 becomes infructuous.
what my respectful submission is,
Absolutely.
my respectful submission, I see what falls from your lordships.
Not on these technicalities.
Lords, I will show some case law that,
On-
Lords, that once an 80 application is filed, the court can do nothing else but to first consider or reject that application. It's only when that
The order was passed,
please, my lords,
the deletion application was
was
there.
on record. It was very much on record.
Then
Lords, my respectful submission is there is no jurisdiction. There is no jurisdiction to consider any other
not
application.
on these technicalities.
Lords, I will show some case law on this point.
Because
Please.
you have to show in the facts.
Lords,
Where there is an
I will show.
application for deletion file. You show us one judgment.
Lords, specifically on that,
Obviously,
I will look,
as
but
the facts.
Lords,
In
what I
such
have,
matter, there is no
What I have.
application for deletion.
We want when an application for deletion has been filed,
please,
for whom an exemption is sought for
Under section 80.
under section 80.
please, Lords.
Once the deletion is allowed, that becomes infructuous.
Will your lordship give me a little time? What I have now with me is a case law saying even if they are pro forma party and no relief is sought, nevertheless, 80 application must be filed and
That's,
must
it.
be
That's not relevant. No?
Lords, if your lordship will give me a little time because I have case
That's
law,
one thing.
please.
How can you, what can be the best argument in the facts?
Lords, my respectful submission is this entire suit is misconceived. This is not the only
You
suit.
will argue there.
Of course, my lords. Of course, my lords. My lords, your lordship may give me a little time. I will see, my lords, if I can.
Understand? Time. Why time on this
Lords,
small
because,
issue?
lords, that's because they filed false criminal proceedings against me, etc. My lords, it's a technical point in my favor. I wish to take it
Very well.
only for that reason.
Okay.
And I have
How
made
much time
multiple. I have made multiple. I have made
What
multiple.
time you want? We'll give you time.
Short take. May I make one more submission? my lords?
Yes,
I have made multiple offers to them to even settle the case.
that's between both of you. We are
Please.
concerned as a court appeal.
Please.
By
You
6
say,
crores is with
1
them.
minute, mister. You say in fact you will satisfy the court. Very well, we'll give you time.
If it's 1 week, my lords, not more.
Okay. At the request of counsel for the respondent, re-notify. Just have it up.
Great. Date may fix me. Date may fix me.
15/7,
Obliged.
42.
I appeal for the appellant plot.
Appear for the respondents.
On appeal, my lord, against an injunction order in a trademark dispute. Lord, I make no spins. And my lord, I use the,
It's a registered mark
Lord,
or it's a case of more of a passing off?
Lord, more of a passing off, my lord, because I have been using it since 2016. Lord, I used it from 2016. It is my name. My lord, because the product is so small, there are only 1 or 2 alphabets, my lord, which can go on it because it's a no spin.
What can be a distinctiveness in this, Mr. Sriranga? VS alphabets.
Yes.
Unless and until it's purely a question of fact. Purely a question of fact that this has attained distinctiveness. Now,
Lord, it's my
VS for what product has attained distinctiveness, you have to satisfy.
Lord, there is not even a plea, my lord, that it has VS has attained any distinctiveness. One, they don't plead that. My lord, what they say, broadly, my lord, is that they started using this VS, which does not connote anything.
You are the defendant.
Yes, it does not say, my lord, as to what is the significance of VS so far as they are concerned. They say that they started using it in 1995, but on the record, there is nothing which indicates that they started using it from 95. They produce bills.
What do you say?
Yes, Your Honor. I'll just brief the facts. The petitioner and the respondent, the plaintiff, I'll refer them to as.
It's not a registered mark?
Mine is a registered mark. I have
contested.
Yes, is a registered mark. Now, Your Honor, for your Lordship's consideration, it is a registered mark, and for your Lordship's consideration.
Where is the mark? Can you just show us?
I have
But it's in the my lord, volume which is filed now, my lord. The document is there. My lord, it is the registration, my lord, is contested, and they don't disclose that fact.
No, that
they
is
produce
false.
Do you have filed
It's
objections?
absolutely false.
Yes, my lord,
And
written statement is
take
filed,
your honor
objections
to the
are filed.
facts, Your Honor.
No, did you go to the concerned?
Lord, I never thought, Lord, I did not contest it because I am not of the Lord view that this VS and VJ, Lord, have any problem in usage as such. Therefore, my lord, I used it from 2016. They issued me a legal notice in 2017.
Yes.
But my lord, they did not take any step. They waited. They filed a suit in 2024.
No.
Lord, Lord, interestingly, Lord, they say they use the mark from 1995. There is no document. In this compilation, my lord, I have produced the bill which they produce of 2002. They say 2002 they were using this mark. Then, my lord, they discontinue this using this mark. That is also produced by them, my lord. It is their document which is before the court. Now, once they stopped it and I started using it, 1 year later, my lord, they start using this VS, and 2017 they make an application for registration. Lord, 31/1/2017 is their application for registration, which is after I started using it. These are all admitted facts, and they wait for 7 years. Then they make an application, my lord. They come with a suit to restrain me.
Your mark is also VS.
Mine is VJ, my lord, which is my name. VJ.
For what? What are the product?
Lord, it's a no spin that I make.
And they are jewelers.
Yes, my lord.
Where is the connection, Mr. Sriranga?
Lord, VJ is my name, my lord. That's all I can use, my lord, on the product. Therefore, I have used it.
Your Honor.
Lord,
Just for a second. He is my employee.
Impugned order.
1 minute.
Just for a second.
You have a registration with VS?
Yes, Your Honor.
With VS?
Yes. And in fact, the documents are produced by them.
1 minute. Mr. Sriranga, if he has a registration with VS, in VS, surely he is entitled to protections.
Absolutely.
Under 28 and 29.
Lord, my submission is this. Lord, he applies after, my lord, I have started using it. That's an admitted fact in the plaint.
You will file objection for
Lord, it is contested. He does not dispute. I have stated, my lord, that he should have been all. Kindly see the, my lord.
Tell us, as of today, the registration exists in its favor?
My lord, he has not produced any certificate which is legally tenable before the honorable court. My lord, the document at page 2 of the memo indicates, my lord, that, my lord, for the purpose of relying on a certificate, it is necessary to obtain a legal proceeding certificate which will disclose
No, but he has annexed it
all the challenges.
43, page 43, who has filed this?
Compilation, my lord, is filed by me.
Now skip page 40, page 6, page 7.
My lord, kindly see, my lord, these are all not legally, my lord, can be used in legal proceedings is what it says. My lord, the certificate itself discloses it, my lord, at the bottom of the page. This certificate is not for use in legal proceedings.
It appears this is every time they say so.
No, my lord. There is a provision in the law that they should, what is the document that can be relied upon? There are judgments which say that it's a basic necessity that you should produce a legal certificate which can be used in legal proceedings. It's called a LPC.
What we are putting it to you is, if it is a registered mark, under the provisions of the Trademarks Act, is he not entitled to protection?
Lord,
he may, see, you may argue that you have been in, using your VJ for many years, much before he got his registration. And yours is VJ, his is VS. Totally, they are at variance.
Yes.
Okay. Now, what is the basis for you? Who has gone? They have gone to the civil court?
Civil court, they have gone.
Against that, what is your prayer in the civil court?
Seeking for, I'll take your lordships to the plaint last page, Your Honor. I've sought for the plaint at last page.
And you are in you are in which goods?
No spin, my lord.
No spin, and they are in jewelry.
No, they are also doing. They say that they also make no spins.
For 1 second, Your Honor, I want to just put one fact which might.
Where is your prayer?
Prayer is at page 39, page 223.
Page 64, my lord.
Page 64.
Prayer.
His,
in the appeal.
One I've sought for is decree of permanent injunction restraining the defendant or his partners, his henchmen, from sale, advertising in any manner, including on the internet, directly, indirectly, dealing in gold no spin jewelry. Now, Your Honor, very important is gold no spin, which I want to bring to your lordship, that what they are dealing with is something else altogether. Now, first, that's my first prayer. Gold no spin and any other similar cognate and allied goods under the impugned
you make a
trademark.
specific prayer regarding their product.
Yes.
They are also into gold nose spin.
Yes, but the fact is 2013 to 2016, he was working under me. He is my employee. And what does he do? What does he do in
this mark VJ and VS is only on the bill?
No, it's on my products also.
It's on the product also?
Products also, and in fact, your lordship, the memo which they have given, in fact, they've given the black and white printout where your lordships will not be able to appreciate the trade dress and the exact same, the way I do my packaging, they do the exact same packaging. My card, VS, I put an elephant, I put something, they put the exact same thing.
They have
just
given
with
up.
a small, VS is in a diamond, and they just put a J, and they try to make, they have a complete understanding on my distribution, my customer base, my clients, my the entire supply chain was known to them because he was my employee. Now, what does he do to them? He tells them that, he's in subsidiary. He's almost like, mine.
No such allegations
And
are there.
what is it that he does? I sell it for, let's say, 1,000 rupees. He sells it for 20 rupees.
In the memo, kindly see, my lord.
In fact, I want to just pass on one written arguments which they had submitted in the court for the IA that they're challenging.
I don't know how are they VJ, VS are deceptive.
They are not
deceptive. We are asking you, you may have gone, where is your infringement prayer?
First prayer is infringement prayer, Your Honor. My first prayer is infringement.
But tell us how VS and VJ are, infringing your trademark.
I will explain.
Lord, I have a right.
1 minute, Mr.
Yes. I will explain. I have established myself from 1995.
You're not understanding. You have done it. Everything is in your favor.
Yes.
How VS, VJ, how VS is infringing, yours is VJ. No, VS.
VS.
How VJ is infringing VS, tell us. Except the commonality is the alphabet V. That's all. And it's a V is an alphabet.
Yes. Now for that, I'll just take your lordships to the memo which they have submitted.
So somebody else.
Just the memo.
Let's assume VJ, VS, VK. or
Yes, 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 I
all
understand.
those things will come in.
Lord, in fact,
Absolutely.
One minute, can
in
you
fact,
have a
VK is also
one
there.
minute, Mr. Ranga.
I'm sorry.
Can you have a monopoly on VS?
Yes.
For all? No. For
I'm
all-
registered, Your Honor.
Right, so you will only.
For VS,
one
I have
minute.
an exclusive rights.
You will only claim to the extent of your registration. If it is, now registration includes V and S as words, as alphabets. The commonality between VS and VJ is only V. Can you have a monopoly on V?
No, I will just take your lordships one step forward. It is not only V. What is VS put inside is a diamond shaped box, Your Honor.
Oh,
It is diamond in color. That is the first commonality.
let's see your registration.
Page 2, my lord, of the memo.
Very well. You want to have a diamond also, your VJ?
Lord, it is, my lord, I can change it, my lord, to a circle.
Let them
Any
change it.
geometrical shape.
Let them change it.
I will
If
use
that
any
is the
other
case-
gem.
Put a circle or something.
Yes, my lord.
He will put that, he will remove that VJ.
Yes.
Your Honor.
My lord, for a minute, my lord, kindly see in that memo, page 42, my lord. For a minute, page 42 in that memo.
So will you change it to?
Yes, I
That's
can
all.
change it
So then what remains?
to any other geometrical shape other than the rhombus. Page 42, my lord.
Yes.
Page 42. This is their own print document. Lord, they started using this VS, which is different from that rhombus, etc. Subsequently, my lord, kindly in the same memo, my lord kindly sees, after I started using it, they tried to come back to the original VJ with the rhombus, but then they completely rebranded it and made it into MJ, which is also produced by them at page 99.
But then that you should
Your Honor,
go, na?
No, correct. The only
I've
vendetta,
taken
my lord,
these-
is, my lord, as they said, my lord, historically I was employed. My lord, I started something on my own. They tried to watch me. My lord, they were thinking, my lord, that I will possibly perish. Once, my lord, my business started picking up, they wait for long years. And my lord, only later they say that they have come back to this rhombus shape and they started. But in the meanwhile, there is no continuous use of that mark at all by
Yeah.
them.
Just 1 minute. So you have protection only in this, nothing else.
Just for a second, I want to also impress your lordships on one thing. They have sought on documents. They say they've been doing this business from 2016 or 17 whatsoever. One iota of evidence, Your Honor.
Forget it.
Forget it. Forget that, Your Honor. Forget that, Your Honor. Please come to page 102.
What is your right in law? Only the protection here. If you have a registration, this is the registration certificate.
As far as my infringement rights are concerned, my passing of rights.
Show us how a passing of case is maintainable.
Yes, Your Honor. The same memo.
Yes.
I'll request your lordships to go to page 45, Your Honor. So page 8 of this memo. From page 8 to page 102, these are almost 100 pages, Your Honor. 100 pages from 2002.
Whose bills are this?
This is mine, plaintiff. This is plaintiff.
But page 65, 66,
Yes.
where is your trademark?
Page
65, 66.
They stopped using it.
Your Honor, there was a transformation in the product that I'm using, but
Doing
I've
the
been
same-
using VS from 1995. I've been producing evidence,
VS
100 pages of evidence. Apart from this, Your Honor, I have.
VS is used,
Yes.
whatever the format, not in the specified rhombus.
Initially, it was
diamond
not.
or whatever it is. You had used it in like this, and earlier you had used like this, and you have been keep changing.
Page
How
some-
will I believe you?
No.
Page
In fact,
77
I'm not
is the last
changing,
bill.
Your Honor. I'm not changing. I'm not changing. To put it in the best way, any company, let's say Coca-Cola. Your Honor.
Nobody in the world should use VS.
I'm not on that.
Then
I'm
what?
not on that. I'll break it down into 3 points, Your Honor. First, VS, let's say one car uses it, maybe not my customer base, not my business, not my care, not my thing. So they can use it. Second, where does this problem come? It is not the fact that he's a stranger who is out of his own creativity come out. when somebody is an employee,
Forget it.
I want to put
You
forward this
can't argue
point.
that. Why not? Can't he have his own business?
He
Merely
can
because
have his
was
own
an-
business, but he cannot say that his business is a continuation of mine in the guise of making
Very
something
well,
of
he
this
will
sort.
not. Let's assume for a moment he has not made out a case. We are asking you, you went to the court, your infringement, your right is only in VS with that rectangular or
Yes.
whatever is that.
Yes.
That's the only protection you will have.
Yes.
You can't have a monopoly on V's. The commonality between, even if you can argue is, you can argue on twofold, saying that that square has been put
Yes.
by him. That may be deceptive. On V, the commonality between you and him is V, the alphabet V. On that, you can't have any monopoly.
Absolutely.
Suppose one person is there, maybe V Srinivas. He will say VS.
Yes, Your Honor.
V Srikanth. He will say VS.
Yes, Your Honor.
He can put it. Either what is there? This is an abbreviated form of my
Absolutely.
same. He can put it. So
I'm Vijay, so.
So the only thing, what Mr. Sri, are you ready to put it something different between other than this?
Not, I'm not too stuck, my lord, on the rhombus. Rhombus is used, my lord. I have checked. Lot of, my lord, these abbreviations have a rhombus because, my lord, hologram also uses that. It is commonly used, therefore, my lord, it is there. My lord, for the present purpose, my lord, I can use any other geometrical.
Whatever you want to use it.
Yes,
see, he has.
I will use a circle, my lord, and not use
as a mark.
rhombus.
He said, I am entitled to protection in the manner the mark has been registered. The peculiarity of the mark is the essential feature of that mark is that triangle or that kind of a thing. Possibly, on a first blush, if one sees so, or this possibly the person comes to you, he correlates the product to him that he has VS with this triangular this thing, and hence possibly related to. In that manner, he's saying it amounts to maybe infringement or maybe passing off. Infringement, he can't make it. Passing off, he can make it because of that. But then the test would be who was the prior user of that mark. We will not go into it. If you are saying so that you will change it, that triangular into different thing, then I think
yes.
Your Honor, I just want to pass the plain documents which are produced, just to show your lordships, it's not only the VS. You have to go. Your Honor, will be pleased to see page 180. It's not only
Of what?
it's the plain document.
VJ, na?
Your Honor, it's not only VS VJ. The way I put forward my products, the way I am marketing it, I put an elephant, they put an elephant. I put a design, they put the same design. What is it? I have the same end customers. Women are taking nose pins.
May not be in the context of trademark. In the case of
Trade
get up,
dress is
everything.
part
would come.
of the trademark, Your Honor. It has to be taken, seen as a whole, not singularly.
Seen as a whole as a trademark, not the get up.
Get up is, I'll produce judgments, Your Honor. I'll take a week's time. I'll put forward my objections and then it may be argued in toto.
See, this get up is not part of your trademark, registered mark. What is registered mark is this.
Yes.
This is not the part of registered mark.
Not that, Your Honor. The one which is on your left. Yes.
This one.
Now,
Is the elephant part of your mark?
Assuming, not admitting, Your Honor, let us assume he puts a circle. The way I put elephant, he puts the exact elephant. Let's say I put some other donkey. He puts another donkey there. It still forms part of the entire trade dress, Your Honor. With a small modification is not going
Is
to
your
change.
mark registered with this get up? No.
Not with the get up, Your Honor. It's a
Color.
in fact, I'll produce judgments, Your Honor. I'll convince this court that
You have
trade.
to produce in the facts.
Yes, with
of
the
this,
facts. Exact
where
same
the limited
facts.
registration is VS. That's all, nothing more.
I'll produce
And with
judgments.
that triangular. And you have anything to say what Mr. Sriranga is saying, they will remove that triangle.
With an open mind, if he comes forward for a settlement where he says he
Why don't you
changes
sit
it.
together?
We have tried, my lord. Kindly, I will show you only two pages. I will not take it forward. My lord, page 77 and 78 of my memo.
Then tell us why did you put that?
Yes.
Why
There's
did you
an
put that?
intention.
I
There's
have
a malified intention.
Why
Lord,
not?
it was they had stopped using this entirely. Kindly see, my
See,
lord,
they
page
have a
77, 78.
They have a
Only two.
registration,
No, correct. But Lord, it has been abandoned. It is only, my lord, because I started using this VJ, they have revived it.
Did they get the registration?
2017 is their application.
When did they use it, till when?
My lord, they used it till 2008. They stopped.
No, 17 got the registration.
No, my lord, in the meanwhile, what they have done, my lord, is initially they used it. They stopped using it 2008 as per the document.
I think then the trial court is right.
Then, my lord.
1 minute, Mr. Sriranga. If you make 1 + 1 2, what he's saying is right. You are the employee. You have taken the fact that he has abandoned, you started using it.
No, my lord.
Obviously.
No, that kindly see, my lord, 2 pages, 77, 78, my lord, of the memo. My lord, it has come to them as a afterthought, my lord, that they will, my lord, register it subsequently. My lord, I had no intent, my lord, because VJ is after my name, my lord, I am Vijay. My lord, kindly see.
That's why that.
Lord, that is commonly used. That is why I'm saying, my lord, I'm not my lord, because the hallmark normally uses, my lord, we see, my lord, I in fact saw, my lord, as
okay, show us one more trademark,
yes,
which is commonly used to us.
Lord, VK is there, my lord. I'll just point out.
It's a matter of trial, Your Honor.
With the rhombus. Just give me a minute, my lord. I will show another registration. VK. There are VM is there. VK is there with the rhombus.
Registered mark?
Yes.
That's right. The registering authority has given that registration, but you don't have any registration.
Lord, I don't have, my lord. But so far as kindly see, my lord, permit me to show this.
I'll file my objections and it will be taken up later. This is not permitted. I have to be served a copy.
I will serve him a copy. Lord, just to show.
Anything on the internet.
Nothing specifically, my lord. This rhombus is used because of the hallmark.
This is a registered mark?
Yes.
That's right. You're not.
No, that's why I'm saying, my lord, so far as the rhombus is concerned, my lord, I will.
Rhombus with VK is a registered mark, has been given to the person who has sought that registration.
Yes, my lord, some third party.
He has also sought with that rhombus, but you did not seek anything.
No, I did not, my lord.
That's the point he is arguing.
Yes, therefore, my lord, I'm saying, my lord, I'm ready to, my lord, I'm not too stuck, my lord, on that rhombus. Rhombus is used by everybody as.
We will have it after 10 days. If you want to have anything, understanding, come to an understanding.
My lord, my own, my lord, understanding, my lord, is because of the fact, my lord, that I was historically sometime employed. My lord, lot of social media, my lord, the clips have been released, and my lord, threatening letters have been written, complaints are filed, lot of things have been done, my lord, in the meanwhile. My lord, it may be a mere formality, my lord. My request is in deference to this order, my lord, my entire business has come to a grinding halt. Therefore, my lord, it's a question of my livelihood, my lord. This is the only business that I run. Therefore, my lord, permit me to, my lord, at least, my lord, use the stock which is available, which I have supplied. All that is, my lord, kept on hold because of this order, because I didn't want to violate.
Where is the inventory? How much is the stock?
My lord, it's I have not produced a document, my lord.
Important.
That I will do, my lord. In the meanwhile, my lord, permit me to use VJ with any other, my lord, with a circle.
Not permissible. I will object.
Today there is a restraint order.
Yes.
It can't be piecemeal. If you want to come to an understanding, you will sit together, work it out.
Yes.
If you can't work it out, what this other submission is made, you have a stock that must be allowed to be sold. We want an inventory to be filed with our proper documentation that you have actually manufactured those products, at least before that interim order was passed by the trial court. Then we will consider it. That's how it should be.
Subject to my objections here.
Obviously.
Not
to what you have to say.
Lord, Lord, if we see the impugned order, my lord, it records a finding that they are dissimilar. The marks are dissimilar. And, my lord, the test that has to be adopted by the court, my lord, for granting an injunction, my lord, that test has not been applied. Plus, my lord, the court also in the initial order says that this is a category of product where people are not so gullible that they will mistake one product to another. My lord, whatever my learned friend is showing, my lord, it's on the bill. It is not on the product. So any friend, other things, everything, my lord, nothing is on the product. Therefore, my lord,
Of
it is
product
a
are
minuscule,
produced.
my lord,
Page 108.
my lord, for identification, it is there. Therefore, my lord, no person,
Is it on the bill only?
all these, my lord, elephant, the other things
Sir,
that
on
he's
the
saying, it's
products-
only on the bill. It is not on the product. There is nothing on the product except that VJ, my lord, for, my lord,
VJ is there now.
A date
VJ
will
is
be
there.
given, I'll
VJ is
produce
there.
all the products.
Therefore,
Very well. You want to look into, sit together and work it out, we will see. When do you want? See,
shortest
that's what
possible
we are
date.
saying. He says he will now remove that. He'll put a circle or whatever is there.
We will
You
discuss
can't
it.
see, if ultimately we have to see the mark as a whole. You can say that's an essential feature of your mark. Oh, that can be possibly said, and you have a registration.
Please.
Tell us, when do you want?
Lord, shortest possible date, my lord, we are ready to,
Just,
my lord,
just at the
negotiate even
request-
tomorrow. Because
At the request of Mr. Srirangal and the senior counsel for the appellant, what do you say?
Last week of.
1 minute, please. What do you say on this? You want to sit together and work it out?
Can sit together, Your Honor.
We have heard the learner counsel for the parties for some time. At the joint request of the counsel for the parties to explore a settlement, re-notify. I have it after 10-15 days.
Lord, matter is coming up before the trial court. They have filed an application for commissioner's appointment.
Yes, I have.
Therefore, Lord, can I ask for
When is the date?
9th?
You take an adjournment, both of you.
Your Honor, one submission. That cannot be permissible because after the injunction, they keep wholeheartedly selling it and spreading
Completely stop.
rumors in the market, Your Honor. And that's why I filed a court commissioner so
How
that
do
the
you-
court
how would you
commissioner
meet
can.
this?
No, my lord, I have
And I
not.
have evidence for this.
Are you selling it?
No, my lord, I have not sold anything. I have not supplied. In fact, my lord, I have video clippings. He has been circulating to say that, my lord, I am a fraud, etc., etc. Letters have been written to all, my lord, retailers. They have, my lord, many of the retailers have returned the product.
How would you answer? If you are not selling, we will take that.
Then let the
submit
court
on
commissioner be
record.
Yes.
appointed.
Mr. Sriranga.
Lord,
You will
that's
file that evidence,
my-
whatever you have.
Your Honor,
Okay.
if he says that he's not selling it, let the court commissioner be appointed. Let the court commissioner do that work. Court commissioner will give evidence to the
We are
court.
only recording Mr. Sriranga's submission on instructions that after that interim order is based, he is not
Yes,
selling any product
Let
with
it be
the
recorded.
impugned trademark.
Let it
Yes.
be recorded and I'll produce
That's all we'll
evidence.
record.
Let it be taken on.
Joint read. At this stage, learner counsel for the respondent number, only sole respondent.
Respondent
Hold
1
on.
and 2.
Who are the other
Respondent number
respondents? Respondent number,
Both the respondents.
so
One is an LLP, my lord.
who is he? Mr. Laddu Lal Jain.
So initially it was a sole proprietorship and then the LLP was formed. So
No,
the
is he
trademarks-
connected with the
Yes.
one? no?
Yes, he's a partner. in one.
Respondents states that even after the passing of the interim order, the appellant herein has been selling the product with the impugned trademark. Full stop. This submission is denied by Mr. Sriranga on instructions. Full stop. Then re-notify.
23/7.
Much obliged.
Some earlier date, my lord. We'll try to negotiate from tomorrow. It's some earlier date, my lord.
What is the date?
23/7.
It's all right.
These 10 days should be
23,
given for-
we are what on 7? I have it 1 or 2 days because we can't have it.
One day earlier, my lord, it could be 22nd.
Just have it on 22nd also.
22/7.
Great.
Yes.
Forty-three.
Call the matter. No? 43. Call it.
43. Bill number 43.
Just say none for the Appellants re-notify.
17-9, 44. 44.
Appellant conductor, my lord.
It's a fresh matter, just shows. It's a fresh matter. No? Just a issue notice.
Notice. 19-9, 45.
I pay for the complainant, my lords. The complainant is the owner of the school, my lord. The complainant is the owner running a school, whereas the accused is the owner of the property, my lords. In 2014, there are disputes arise relating to stoppage of electricity, water, and various other things. We file an injunction suit, and we get a decree in 2024. Permanent injunction is being granted. Thereafter, my lords, the accused stops me from entering the premises. Thus, the cause of action has arise for this violation of this order.
Which order? Which order of this court?
Page number 19 is the order, my lord.
Where is the direction?
19, my lord. Direct to provide the basic facilities such as electricity, water supply, and others. Now I'm not even being allowed inside the property, my lord.
This is some order in the suit.
Please, my lord.
Mandatory. You can see the execution. File an execution. Why a contempt?
We have filed an application already before that. We have filed an application for police protection, my lord. That was herein dismissed.
But what happened to your execution?
It is it's still in course.
We will go there. We will not entertain.
Please, my lord, notice has been.
We will not. Sure, the.
Please,
How
my
can there be two parallel proceedings?
Please, my lord, I'll seek necessary instructions, my lord.
Pardon?
I will seek confirmation.
No need, no need. We will record it. You have filed an execution, you will pursue with
Please,
that.
I will, there's a different counsel arguing in the execution. I'll seek necessary instructions, my lord.
What? Why? What? We will say so.
Please.
We will say so.
Please.
Just say that the present contempt petition has been filed seeking action against the respondent for disobeying the judgment decree dated 27/4/24 of Roman II additional civil judge and JMFC at Shivamogga in OS number 191 of 2014. We'll stop at the outset. Learner counsel for the contempt petitioner states that the contempt petitioner has also initiated execution proceedings seeking execution of the aforesaid judgment decree of the learned additional civil judge. If that be so, comma, the present petition, we refuse to entertain the present petition, accordingly dismissed.
46. Serial number 46.
Lords, I appear for the appellant, my lords. In challenging the order, my lords, which had directed reinstatement of an employee with 75% back wages, my lords. But there's a finding in the same order, my lord, that the absence was unauthorized. And even the medical certificate which was provided also, it is not proper, my lord. Despite such a finding, he has been directed.
How many days unauthorized?
My lords, there were about 42 days.
And and this is only the first occasion?
My lords, I mean.
And what is the penalty?
My lords, they had reduced it to 75%.
No. What are the penalty imposed by the disciplinary authority?
My dismissal, my lords.
Dismissal on one occasion for 42 days.
He was dismissed and then he was, writ petition was challenged. And he was again reinstated, my lords. And then he was given the back wages then. But now full back wages and plus there's a direction for reinstatement when he had already attained the age of superannuation when the petition was pending before the order.
Oh, that order stands?
That order still stands. It's a subject matter of challenge.
The notice has been issued, my lord.
But now tell us one thing, this reinstatement must not relate back to the date when he was in service.
It should ideally, my lords, it should be
The
clarified.
order of the labor court, when did he attain the age of superannuation?
Lords, 30 June 2017.
And when is this order passed by the labor court? In 2012,
2012.
when he was not retired.
No, that time he was not.
Obviously, reinstatement is proper then.
Yes.
Now,
Lords, the, yes.
this is the order under challenge. He says reinstate, modify, employ, reinstate. And what is the period of, when was the initial
Lords,
termination order passed?
My lords,
2002.
2002, my lords. The period of absence is in para 2, which is 10 September 2001 to 22nd October 2001. My lords. In the findings, my lords, I may read para 8, my lords, which is at page 21, my lords. Para 8. It is not in dispute that the workman was unauthorizedly absent. Though there is a submission made that it was on medical grounds, the medical certificate which has been produced does not indicate any particular reason justifying the absence of the workman. However, there being a medical certificate and there being an illness on the part of the workman which is not in dispute. I am of the considered opinion that the Labour Court has rightly considered the matter and passed the order. However, the Labour Court also ought to have into consideration that there was an unauthorized absence and there ought to have been some punishment which was imposed to the workman. Hence, for the reason exercising the power under section 11A of the ID Act, I pass the following order. Allowed in part, the order dated, order passed by the Labour Court in ID number so and so is modified directing the employer to reinstate the workman. The employer is directed to grant continuity of service and consequential benefit. However, the back wages awarded by the Labour Court is reduced to 75% of the wages as on the date of the award. And para 5, last 3 lines, it has been submitted that he had attained the age of
notice.
My lords.
You are issuing notice.
Notice has already been issued.
On.
Yes, my lords. And
who is appearing?
And they have entered appearance also, my lords. The respondents.
What is the number, man?
But last occasion they had not appeared, my lords.
Just say none for the respondent, re-notify.
My lords, the contempt petition was on 23rd, my lords.
Where is the contempt?
The next court, my lords. On 23rd of this month, my lords.
Why next court? Just have it then, which is the date?
23rd July.
Yeah. Just have it one day before that. None for the respondent, re-notify.
22/7,
Obliged.
47.
For petitioner, your lordship. This is a case for appointment of on compassionate ground, your lordship. It was rejected on the basis that he is an adopted son, not a natural son, your lordship.
Have it some other day, ma'am.
A short date. may
Just
be
say
given, your
re-notify
lordship.
on.
Six, 8, 48.
Great.
Yeah, for the respondent.
Serial number 48. 48, serial
None
number.
for the appellant, re-notify. Oh, he's there. Just say that. Just cut that.
48, sir.
Just tell him.
Please, there.
Sir, serial number 48. Shri V.S. Naik.
I appeal for the appellant.
Yes, we will have it some other day, Mr. Naik.
Very well. Whatever.
Notify all.
14-8. 49. 14-2.
Yes, President. I pay for the respondents.
What is the issue?
Survey.
Just show us. It has to be argued.
Actually, sir,
Further report has been submitted by me whether to inform the honorable court whether the temple manor that is situated in the midst, whether the water level has not receded for us to enable us to go and visit the temple.
Just say re-notify all. We'll hear it.
13-8. 50.
That's time for the appellant. Also the full case on the hands, please, my lords.
2013, please, my lords, there was a policy where 50% of the setback, my lords, in a building to be constructed, lords, if there any deviation, it could be set off by using the TDR. There is a lot of mischief that used to happen. 2017, it was legislated, restricting it 25%. Now, the concession that was given, my lords, was only 25%. Case on hands, my lords, 2013, please, my lords, they have secured a plan sanction as per the then bylaw. They don't construct, my lords. Later on, they come to us for a sanction plan. We say, my lords, the earlier bylaw has changed. Now, as per the present bylaw, we will not permit you the concession of the setback, my lords, deviation. That, my lords, has been heard and disposed of, allowed, my lords, by the learned single judge, over which, my lords, we are in an appeal. As on the day they have submitted the plan sanction, whatever, please, my lords, was the bylaw that is in existence, we can, please, my lords, sanction it. Now, 50%, please, my lords, of the deviation was earlier. There's a lot of mischief, please, my lords. The legislature debated it and condoned, set it, my lords, to fix it to 25%. So TDR can be loaded, please, my lord, transferable development right, can be loaded only to offset up to 50%, please, 25%, please, my lords, of the setback area. So that as the things stand, my lords. Now, if
we'll have it some other day, let's see.
Please.
Re-notify on.
May I request for shorter date, my lord, because
We'll give you, just say whatever is August, give it somewhere in.
11-8.
Blind.
I will just run through this.
Serial number 51.
51 is state appeal, my lord. Lordship
Comment to
permits, I would take out notice on the delay application, my lord. There's a delay of about 86 days.
Notice on delay.
18-9. 52.
Lord, appearing for complainant, my lord, in this matter, kindly turn to page 12 of my lord, the order, where there is a positive order is issued to the respondents to grant permission to the petitioner trust to run the school for both primary and high school to conduct classes from standard 1 to
What is
10.
this? Just give the file, ma'am.
A notice could be issued, my lord.
I have a meeting. We have to give dates there. See, we have to get up. Just give the dates, ma'am. Who appears in that 230 matter?
67.
We will have it tomorrow, your matter. I think it has come from Friday now.
Very well.
Who is the other side?
Next matter, my lord. 53, madam.
Yeah, 57. My lords,
My
my
lords.
learned friend to the responding came because may I request for the Wednesday or Thursday, my lords? 57 serial number.
We'll just give the court officer, will give you dates.
My lords,
You
may
get
I
up?
make a request,
Yes.
my lords, can it be on the top of the list, my lords, because it become infractuous if they are adopted.
We cannot
I
say so.
understand your lordship's board, my lord, but
We will see it. We will see. We'll try to. Today, because of something, we have to get up. That's the
Very well,
reason.
I
Otherwise, we would have
understand.
continued.
Matter, my lord, serial.
your lordship
Next
will be
matter.
tomorrow's.
Yeah, Mr. Kulkarni, we'll have it some other day.
My lord, next matter, serial 53.
We'll give you. We'll give you.
My lord, serial 53, my lord. Petitioners are the purchaser of the auction site, my lord. My lord, they are succeeded and they paid the 25% of the auction price, my lord. After 2 months, they return the auction amount by saying that.
This is a writ appeal. What is the urgency?
Writ appeal, my lord, there may be a threat of, my lord, put the site in public auction, my lord.
Who is appearing for the receipt?
BDA, my lord. K. Krishna appears for BDA, my lord. Only for interim protection gives, my lord, then.
We will see. Just have it next week.
My lord, serial number 54. One mentioning.
My lord.
You are giving a date.
My lord, 54, my lord. Contempt matter, my lord.
1 minute.
My lord, 54.
I am for the respondent. It's a commercial appeal. Concurrent orders in my favor. I succeeded in the award. I succeeded in section 30.
We will see it. Mr. Joshi will give a date.
Serial number 54. my lord.
67. I'm only mentioning the 67. There is no stay. When the matter was heard before the coordinate bench, the court was not impressed and they merely requested me until the next day, don't do anything. That oral assurance had been given. There is no order on merits.
Who appeals for the respondent?
For the appellant, my lord.
Appellant, I'm
I am for the
here, my lord.
Appellant, no, you are for that.
Lord's, the execution petition is there before the commercial courts. It's on 29.
Lord, I
I'll
intend
pray
to
for a
write
time
to-
on 16.
I intend to
Senior
write to them.
counsel Naveen Pava will appear, my lords.
I intend to write
Just
to them.
1 minute, please.
Yes,
I intend to write to them formally saying that the court has been informed that my oral assurance will no longer work. You are entitled to approach the honorable court for its pure merits. If he wishes to, he can do.
On 16th, it can be posted.
We will see it. We have to see our convenience also. Yes, Mr. Reddy.
230 matter.
I know we have to have it some other day, Mr. Reddy now.
My lord, 54, my lord.
Tomorrow or day after.
How is the position?
Emergency. We were all ready, but I was not
My
there.
lord, the learned AG is appearing in that matter, the WAC matter, 230 matter, my lord. The AG has a difficulty the week. May I kindly have it next week sometime, my lord. This whole week, my lord, he is.
It can't be difficulty for
next,
the entire
Next week, just give
Monday,
it
my lord.
next week.
Next Monday, my lord.
My lord, 54, my lord. Fresh matter, my lord. Contempt matter, my lord. The lordship may issue notice.
Next week, my lord, 14th, 15th may kindly be avoided.
Which matter, Mr. Patel?
Same matter.
Work board matter.
Okay.
Three of us are there.
Which dates you say?
14th, 15th, I'm not available, my lord. Anytime next week.
Would it be day after
Have it
tomorrow?
then 16th. Yes, 16 July.
16.
My lords, may I make one mentioning, my lord. Contempt matter, my lord. 63, my lord.
16 to 30.
Last 3 date has been listed, but it is the urgency that was.
What about this matter?
It's regarding that.
And also, my lords, few days back, my lords, in that case, my lords, they are caught doing mining illegal, my lord.
Ma'am, do one thing. 1 minute.
My lords, they are caught doing illegal mining.
No, nothing off. We'll have it tomorrow.
My lords, serial number 63, my lords.
Your lordship.
There's one urgency, my lord. Serial number 63. May I make a mentioning?
Continuous bomb blasting. Body conduct.
Just have it. We'll have it Monday. Monday.
Your lordship.
Fresh matter, my lord. Contempt matter.
Contempt, we will see it. No urgency.
Serial number 63, my lords.
That matter Monday.
Monday.
Court
officer?
Case ಆಗ್ತಾ ಇದೀವಲ್ಲ petition ನನ್ನ ಹೆಸರಲ್ಲಿ. ನಿಮ್ಗೆ ಏನು ಕೇಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವ್ರು ತಕೊಂಡಿಲ್ಲ ಅವರು.
ಇಲ್ಲಿ ತನಕ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು ಇವರು
Court officer?
Did it?